Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. Not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Good morning, everyone. I swiped myself out of the stream while the intro was playing. And I was like, oh no, is it going to cut off the intro? Like what? But I guess it didn't. I guess you heard the intro and you didn't even know about it. But I just told you what had happened. So hopefully it won't happen again, but you never know. You never know because every day is a new day. And you never know what is going to happen. In the good news category, my Ellen Greenberg stream part 1 came back yesterday miraculously. I'm aware of Kelsey Fitzsimmons. I'm going to respond to you in a minute. I don't have the decision yet, but just hold on a minute. I know everybody likes to be the breaker of the news, but the Ellen Greenberg streams, both of them are up. The part 1 that I was doing yesterday on Ellen Greenberg got cut off while I was live. And then they sent me an email. YouTube was very concerned for me. They thought I was having ideations of, taking my own life. And so there was that. And then it came back. I appealed it because it said that it was, whatever. You're not allowed to talk about things like that. People taking their own lives because apparently they think you're promoting it or something. I don't know. And then I went live immediately with part 2 and I couldn't. But here's the thing. They put an 18 and over warning on it. They demonetized it as unfriendly to advertisers. And I don't care about any of that. What I care about is that the show gets shadow banned. So it doesn't come up in anybody's, homepage. It doesn't come up in anybody's suggested videos. And YouTube has a way of shadow banning videos like that. And the problem that I have with that is that people don't find out about the Ellen Greenberg case, and they don't find out about my opinions on the Ellen Greenberg case and the deep dive that we did yesterday. So if you would be so kind, if you happen to be on Facebook, share the stream out. It's the only way it's going to get out there to other people. I do not have the time, effort, desire to keep fighting with YouTube about it. They did what they did, and at least it's back up there so that you can watch it. Other people can watch it. And, it had to do with the 911 call and what Sam Goldberg said on the 911 call about what Ellen did to herself. And I just don't have the time or the energy to fight it. And I watched the Hulu documentary last night too. And I'm so glad that I didn't watch it before the stream, because I will fill you in on a little tidbit that I think his name is James Schwartzman, who happens to be the uncle of Sam Goldberg, came to the apartment the day after when it was being cleaned by the professional scene cleanup people that the building manager called, and took all of Ellen's electronics. Took them all, her phone, her laptops, and had them for a certain period of time before they were turned over to the police in that case. But of course, when the police went to execute the search warrant on the Philadelphia apartment where Ellen Greenberg lived with Sam Goldberg, not only had it been professionally cleaned by a crime scene cleanup, who knew there was such a thing? Private companies who do crime scene cleanup. And Scott, LawTube's most hated mod, and I were talking about it yesterday. It's big business now because the police, after they, are done with your scene, they don't clean it up for you. You have to call a special company to do that. And so when they went to execute the search warrant, the place had been professionally cleaned, and Sam Goldberg's highly influential attorney or judge, some people say he's a judge, Schwartzman, took the electronics. And so there's no chain of custody for them. And the Google searches, who knows about the Google searches? And so there's a lot more sus to the Ellen Greenberg case than I thought. What I'm hoping happens, and I'm hoping to, well, you know what? I'm not going to tell you what I'm hoping to do. A lot of times when I say what I'm hoping to do, other streamers like steal it and then they go do it before me. So you know what? I'm just going to keep my mouth shut. I'm not helping any defense prosecution teams or anything. So sometimes I have to be careful what I say because then I'm helping prosecution in a case where I firmly believe that the defendant is not guilty, like in the Karen Reed case and or some other things like that. But in any event, Kelsey Fitzsimmons' appeal has been decided. I can't get the decision yet. I can't get the decision yet. Oh, it's only, there's no written opinion. So me waiting for the decision is going to be pointless. Thank you, Mass Dad, for telling me that. But here it is. Here it is in the court docket on Kelsey Fitzsimmons. And it's very small font, but I'm going to read it to you. This was just this morning filed in her docket. It says, notice of docket entry received from the Supreme Judicial Court. Judgment. Following close review of the defendant's petition and appended materials, the Commonwealth's opposition and appended materials, including a transcript of the hearing held on September 11, 2025, and the judge's orders, this court concludes that the judge did not commit an error of law or otherwise abuse her discretion. Accordingly, it is ordered that the petition is the petition be and hereby is denied without a hearing. And that's on Kelsey Fitzsimmons. She will remain in jail. No hearing, no decision. Sorry, but it says they listened to the audio. It said they listened. Well, no, it says transcript. You're right. It says they looked at a transcript. Gray Space says I hate it here, meaning not here on my channel, but Massachusetts, I think, in general. And Spacey Stacy says Kelsey's being railroaded, and Patty says the fix is in. I mean, I had my thumbnail ready to go for the decision, but apparently, according to Mass Dad, who knows all things Massachusetts procedure, this is it. This is the decision. It is one line, and there will be no written decision. So thank you to everyone who emailed me this screenshot of this docket entry. And Kelsey Fitzsimmons will remain in jail for now, which is wild to me. Wild. I thought the Americans with Disabilities Act was a great argument. But apparently the one panel SJC judge did not believe so. I don't know what the next path is. I don't know if they can take it to federal court because of the ADA is a federal statute, if they can pivot over like they did in Karen Reed's case. So I'm just not sure. I don't know if they can appeal to the entire 7-judge panel or if they would pivot to federal court. Massad, if you're here and you have an idea of what the next route would be, I don't know. Hi, Kelly Reed. Good morning, Kelly Reed. Kelly says, good morning. The Kelsey case is unbelievable. It is. And so that is it. I do not know what next steps are. You can't just go straight up to the U.S. Supreme Court. No, there's a path that you need to take before you're allowed to get there. And then you have to ask them with a writ of certiorari to see whether or not they even will decide to hear it. But that takes forever. The full panel would defer to the single justice, says Mass Dad. Thank you. If you have any questions regarding Massachusetts procedure, Mass Dad is your guy. Not only is he from Long Island originally, but he's now been in the Massachusetts court system for, I don't know, maybe decades. Oh, thank you, Elaine, so much for your very generous Venmo. She says, I'm running late, but I'm disgusted. I mean, they've already did practically everything necessary. They filed motions to reconsider, to sue on ADA grounds. Mass Dad says they'd have to file a federal lawsuit. Did they do that in the Karen Reed case? And I don't recall now, because I remember when it was a double jeopardy issue with regard to, but that was also a final disposition of the case, and that's why it might have been different. And so I don't recall. And so is she confined now for 180 days? Did the judge actually set her sentence at 100? Let me just read through these notes real quick because they're super, 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 super small. I thought I saw somewhere that it was 180, like 6 months. But remember, it was Dreckler who was the last judge, and he says, oh, look at this, in the 10-7 entry in the docket, the pretrial conference was held as scheduled, and that's the one that was on a telephone call, like a party line conference call. And it says here, per the court, any further court dates are to be attended in person for counsel of record. And then today, the notice of entry from the SJC that denied without a hearing. But where is it that I saw that it was 180 days that they were confining her to? They made a motion to reconsider. That was denied. I mean, I hate to say it, but they may have exhausted all of their options. And the law is clear, hence the SJC decision says Mass Dad in Massachusetts. And yeah, federal lawsuits take forever. She may be out before then. There's no order. That's it. One sentence. I don't know how to explain it to you in a way that makes it make sense. So just continue to channel your outrage, continue to donate to Kelsey's fund, continue to write her letters, because I think the letters are really helping her spirit. And since I did not plan on having this stream on Kelsey Fitzsimmons right now, because there's not a lot to say other than that the appeal was denied, go to my last stream on Kelsey Fitzsimmons if you'd like to write to her. There are very, very long instructions on what you can and cannot send, and how you need to send a letter. As is, oh, hang on one second. Thank you, Kyle, for sending this to me. All right, there's a little bit of a longer explanation on the Mass Appellate's Court website. And thank you, Kyle Sharkey, for sending this to me. And we will read this together. This is on, again, Kelsey Fitzsimmons. Judgment. This matter came before the court, Judge Dewar, DEWAR, on the defendant's petition pursuant to General Law 211, Section 3, filed on October 2nd, 2025. The defendant seeks relief from an order of the Essex County Superior Court dated September 11th, 2025, vacating a prior order of release and ordering the defendant held without bail pursuant to General Law 276, 58A. The judge issued a further written order on September 16th of 2025, denying the defendant's motion for reconsideration. The Commonwealth filed an opposition to the petition on October 9th, 2025. As the Commonwealth concedes, this petition is properly brought before the court. Period. Following close review of the defendant's petition and appended materials, the Commonwealth's opposition and appended materials, including a transcript of the hearing held on September 11th, 2025, and the judge's orders, this court concludes that the judge did not commit an error of law or otherwise abuse her discretion. We talked about this more times than I can count, how wide a judge's discretion is. Appellate courts are very hesitant to overturn a judge's ruling unless it is way outside the bounds of decency or so egregious. And I hate to be the bearer of bad news, but that's the way it is. Appellate courts do not like to overturn rulings based on judicial discretion. Accordingly, it is ordered that the petition be and the same is hereby denied without hearing. And that is signed by Judge Dewar. Let me just say. Oops. Contrary to the suggestion in the petition, the judge did not revoke the defendant's bail pursuant to 276-58B. Rather, pursuant to the last sentence of 276-58A4, second par, on motion, a second paragraph, let's just say, second par. I'm thinking of golf and they're talking about a paragraph. All right. Let me start that sentence again. Rather, pursuant to the last sentence of General Law 276-58A, that's the dangerousness statute. 4, second paragraph, on motion of the defendant, the court reconsidered the bail order and concluded that because of a change in circumstances that had arisen, the defendant's inability to comply without intense pain with in-home scram alcohol monitoring, a condition of release that the court viewed for reasons stated in the court's order as critical to reasonably assure the safety of another person and the community if the defendant were to be released on home confinement. No conditions would reasonably assure the safety of the named person and the community. Again, Noonan. Hang on a second. I'm going to pull up the actual document because I just got the actual document, which is so much easier to read than these notes. So give me a second. Thank you very much. And that way we can have it all in one document, and it is much easier and prettier to look at, even though the decision sucks in my view. Oh, people in the chat say Kelsey is watching. Hi, Kelsey. I'm sorry about this. Okay. Let's pull up the actual document itself. And here it is dated. This just happened to just drop today. Pretty quick. Again, they filed it on an emergency basis. So let us start from the beginning. Commonwealth versus Kelsey Fitzsimmons. This is the judgment of the single panel of the SJC. This matter came before the court, Judge Dewar, on the defendant's petition pursuant to General Law 211, Section 3, filed on October 2nd, 2025. Right, this was a de novo bail review, if you recall. The defendant seeks relief from an order of the Essex County Superior Court dated September 11th, 2025, vacating a prior order of release and ordering the defendant held without bail pursuant to General Law 276-58A. Footnote 1, which reads, contrary to the suggestion in the petition, the judge did not revoke the defendant's bail pursuant to 276-58B. Rather, pursuant to the last sentence of 276-58A, 4, second paragraph, on motion of the defendant, the court reconsidered the bail order and concluded that because of a change in circumstance that had arisen, the defendant's inability to comply without intense pain with in-home scram alcohol monitoring, a condition of release that the court viewed for reasons stated in the court's order as critical to reasonably assure the safety of another person, Noonan, and the community. If the defendant were to be released on home confinement, no conditions would reasonably assure the safety of the named person in the community. She's got a GPS ankle monitor. Explain to me how the alcohol monitoring in and of itself makes her a danger to the community. She already is wearing an ankle monitor. Massachusetts does not have the scram device that monitors alcohol intake through your ankle, which they have in other states. It's every 30 minutes it monitors your alcohol intake through perspiration around your ankle. This method requires Kelsey, who was shot in the chest at point blank range, still has bullet fragments in her chest, has undergone 7 do we need to go through it again? 6 surgeries, 53 days in the hospital. She was airlifted to Massachusetts General. We listened to the recordings the other day. The EMT recordings. It was chilling. The judge won't consider an alternate method that wouldn't be painful. None of it makes sense. Collapsed lung, fractured ribs, lacerated liver, among other injuries, and 6 surgeries. And not to mention having her 5-month-old infant ripped away from her bosom. But no, we don't want to consider any less restrictive measures. We don't want to consider allowing her to leave her house to go pee in a cup, even though she's wearing an ankle monitor, because she could be dangerous and go after Noonan. Really? Really? Is that what we want to believe? No conditions would reasonably assure the safety of the named person and the community. As the Commonwealth notes, nothing prevents the defendant from requesting relief pursuant to the same provision if and when the defendant can make a showing that information exists that was not known at the time of the hearing, or that there's been a change in circumstances, and that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of any other person or the community. Okay. So I guess if she's now willing to endure the pain, or it's going to be less painful for her, because she did say, and Tim Bradel did say to the court, Judge Kathleen McCarthy Naiman, remember, we listened to it. She can do it, Your Honor. It's just painful. The probation officer who testified, who's actually like the assistant chief of probation, testified that she was compliant. She was not in violation of the conditions. He wouldn't have reported her. But instead of maybe impeding her healing and causing her great pain, Tim Bradel decided to go in on his own and say, you know what? And she did. Can we do a less restrictive measure? Can we have her pee in a cup? It's acceptable. Yeah, the judges, I don't know. Massad says they can also propose another bail package that the Commonwealth agrees with, that the judge signs off on. Yeah, which is so interesting to me, because during the hearing, the Commonwealth really didn't have a whole lot of opposition to this. And then in their appeal, they took a completely opposite position. They were like, yeah, no, we think she should stay in jail. I mean, is this about justice, or is this about another pinning it on the girl and keeping her in jail and keeping her baby away from her? I'm at a loss for words about how your constitutional rights go to die in Massachusetts. Because it would have been really easy for the Commonwealth, for an ethical prosecutor to just say, Your Honor, we don't want to cause the defendant pain. We understand that she was shot in the chest by one of our own. And the extent of her medical condition and her injuries. And we don't mind if she just tests another way. It would have been really easy for the Commonwealth to just agree to that, but they just didn't. And I want, and Mascot, if you have any, opinion on why they wouldn't just agree to it, aside from just being dicks. Yeah, I said it. Because this is how I feel about this.
Warning, bullshit alert.
Let me finish this and then I'll address this, Kelly. Hang on. The defendant seeks relief from an order of the Essex County Superior Court dated 9/11/25, vacating a prior order of release and ordering the defendant held without bail pursuant to General Law 276-58A. The judge issued a further written order on September 16th, 2025, denying the defendant's motion for reconsideration. The Commonwealth filed an opposition to the petition on October 9th, 2025. As the Commonwealth concedes, this petition is properly before the court. Following close review of the defendant's petition and appended materials, the Commonwealth's opposition and appended materials, including a transcript of the hearing held on September 11th, 2025, and the judge's orders, this court concludes that the judge did not commit an error of law or otherwise abuse her discretion. Accordingly, it is ordered that the petition be and same is hereby denied without hearing by the court. Allison S. Cartwright is the clerk who signed it. I don't know why the judge didn't sign it. Dated today, October 15th, 2025. Maybe the judge's clerk is allowed to sign it. It's all about protecting the judge, Melanie. They can't have another Cannoni, says Big Old Dog. Right. I mean, I can see that they also don't want another Lindsay Clancy, right? I mean, I can see kind of both sides of it. But again, the only thing that Kelsey is indicted with is assault. That's the only thing that the grand jury returned a true bill on, okay? She didn't kill anybody. Think about it that way. I mean, listen, we know John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. But Karen Reed was charged with second-degree murder, okay? Second-degree murder. And she was out on bail, no ankle monitor, no alcohol monitoring. Make it make sense. Can you? Thank you, Carol Legal, for gifting 5 memberships. Criminal defense attorney for 35 years. Thank you. Thank you so much. And also thank you, Carol Legal, for becoming a member. And welcome to the 5 new. Carol Legal, can anyone with a bar license file a bar complaint? No, I would never, ever, ever. It would be completely against all ethical rules and bounds of decency for me to ever suggest that anyone file a complaint against the judge. I would never suggest that. No, I would say, no, don't do it. It doesn't help, but I'll take your $5. Thank you for that. No. Beach Life says, absolutely do not believe that they listened to the audio of the court that day. If they read the transcript, it's not the same at all. The appellate court has a very narrow role, okay? The appellate court has to decide whether or not the judge abused her discretion. And because judicial discretion is so broad, that is what this one judge panel decided to do. But I am going to tell you that you need to look far deeper than Kelsey Fitzsimmons' case, far deeper than the Karen Reed case, far deeper than the other case that we're going to look at today, the appellate arguments on Dennis Bateman, because Dennis Bateman is a man who's been in jail since 2007. We're going to get to that in a minute. And his appellate argument is, we just found out that the Commonwealth altered some of the recordings of Dennis Bateman's statements to the police. They're completely altered and pieces are cut out. And we just had a couple of Experts review them. Yeah, the judge closed the Ellen Greenberg case. Yeah, that was the right thing to do. That was the last thing left. It had already been settled. Ellen Greenberg's case was settled in February, and they were paid some money it was a civil suit. My head wrote it off. And then the last part of the settlement that was outstanding was this independent review of the original autopsy report. And so that is what happened. I did watch the Zoom hearing yesterday. I was on the Zoom. It was very short. The judge actually came on and she said, listen, we have very strict orders for everyone who's on the Zoom about broadcasting, et cetera. She's like, I don't know if you're not in Pennsylvania, whether or not I can enforce it, but I expect that none of you will do that. And, I'm going to hold you to your, I forget what she said exactly. But all they did is say, the plaintiff's attorney said, Your Honor, I'm just here to report that the Commonwealth did what they said they were going to do, because Pennsylvania is a Commonwealth too. And they did review the autopsy report. They came back. We disagree with the conclusion, but they did live up to their end of the settlement or their end of the bargain. And so therefore the case is closed, and that is the right thing to do. What the Greenbergs are going to do next, I do not know. What they can do next, I do not know. But as I said, please share those streams out, because YouTube is shadow banning, and it's not right. That is another case that will outrage you if you don't know about Ellen Greenberg, and so many of you did not know about Ellen Greenberg, and so I was surprised that a lot of you did not know. It's a case from 2011. So I don't know what next steps are for Kelsey at this point, unless they are able to go in and say, all right, she'll do it. She'll do it. She'll abide by the original conditions, just like we said she would do it. She'll do it. She'll endure the pain just to get out of Chicopee. And that may be the next thing. And that may be the way to get out of it. There was no internet in 2011. Who said that? Silly. Yeah, I know. People weren't texting in 2011. I'm like, yeah, they were. Leanne says, Canoni and this judge are competing for the most egregious award of the year. Up there with Judge Gull, right? Is that true, Pure Duckery, or are you making a joke? McCarthy was Judge Canoni's mentor. I don't know. But this reminds me that yesterday somebody sent me an email and said, it'd be so cool is if you got some of the original documents from the Salem witch trials and we went over them together. And guess what? They do exist. So I fell into that rabbit hole last night. They do exist. And that might be an interesting thing to do, because here's what Chloe Bitts, so we quit, says, mass courts framing women since 1692. Oh, yeah. And Kylie says, turns out they never stopped. They never stopped. And the proctors were involved in that too. Yep. Crunchy Frog says, yeah. And all the proctors in the Salem witch trial. Yes. I do. I have the witch trial documents. It's crazy. They're written in pen and ink. They had more than one court reporter in the room because, they had to write it down pretty quickly. And it's interesting to see the language and, the language, like the Old English language. And, like these girls were acting crazy. And there's a theory that some of these girls were acting crazy because of the rye went bad. And that whatever this ingredient was, I think it's called ergot, is also contained in LSD or acid. And so it can make people appear crazy. Wild. Hold on. And so that might be a fun thing to do for a little bit of, palate cleansing. And to just see how this has been going on since 1692 in Massachusetts. So please, if you can, donate to Kelsey's Give, Send, Go. Please write letters. I will keep you fully apprised of whatever it is that's going to happen next. And hopefully, maybe they can bring her that thing in jail and have her blow into it. And maybe it's causing less pain now. Ergo. It's called Ergo. Thank you. Thank you, Tina. Is it French? Ergo. Like, it's called ergot. I didn't even remember if I remembered the right word for it because I fell into that rabbit hole last night. Call me Alice. Thank you, Tina W. And so, oh, look at that. Oh, Sheila says, an ancestor of mine was accused of being a witch. We have the original petition. Ooh, can you send it to me? My email's in the show notes. Fanbase at mlittlelaw.com. I would love to see that. Oh, Sheila. All right. Thoughts, questions, comments, concerns on Kelsey Fitzsimmons before we pivot. Casey says, Mel, the way you organize your shows while giving us all the wisdom and insight is such a gift. I learned so much from you. Thank you. Thank you for watching. Thank you for watching. Thank you for hitting the like button. Thank you for sharing the streams out. Thank you for taking an interest in these cases that don't have a lot of publicity and a lot of people are not interested in. But I can only cover cases that I'm really passionate about, as you know. And that's why I'm always outraged, because the things I choose to cover outrage me and they should outrage you. And people need to know about these cases. We're going to watch Stephen Gagne argue in the SJC against Dennis Bateman getting a new trial. And Stephen Gagne is the prosecutor who prosecuted Brian Camp. Do you remember? And Brian Camp. Remember him? Stephen Gagne? We're going to get to see him again, because I think we're going to do that one first before we go to Adam Montgomery's in New Hampshire. Because when I turned on Adam Montgomery this morning, the sound was so bad. There was this horrible humming. And I'm like, if this continues, I don't want to even cover it at all. And then I knew something might happen with Kelsey today, but had to pivot on the fly, as we do. And so if you want to say some words of encouragement to Kelsey, she is watching, I am told. So you can put them in the chat. Thank you, Casey. And thank you, No Drama Mamashi, for being here for 14 months and says, hello, hello, hello. Yes, I'm here. And Joel, thank you for becoming a new member. Appreciate you guys so much. All right. Let's talk about Dennis Bateman. I'll give you a brief rundown about Dennis Bateman, who he is, what happened. We did it on another stream, and I never got a full chance to read all of the briefs, but the SJC arguments were yesterday, and so we're going to watch those together. Dennis Bateman has been in prison since May of 2007. In May of 2007, after a 12-day trial, I have some show notes in the below the video. After a 12-day trial in May of 2007, a jury convicted Dennis Bateman on 2 counts of murder in connection with the strangulation death of his friend, Brandy Waryasz, and her unborn child. She was 32 weeks pregnant at the time, at a Deerfield gas station in Massachusetts. He was also found guilty of armed robbery. Brandy Waryasz was 21 years old. She was 7 months pregnant. She was working as an attendant at the Deerfield Sunoco station on the night of April 16th of 2005 when she was killed during a robbery. The prosecutor said that after killing Brandy, Bateman made off with $350 from the register and used the money to buy, oh, it's ergot, Tina. Hello, she says she's wrong. Oh, thank you, Tina. It is ergot. Okay, good. All right. I think I said ergot, whatever it is. Apparently it mimics LSD. So apparently, according to the prosecutors, Bateman made off with $350 from the register, and he used the money to buy, I don't know. If I broke this in half, what would you say I did to it? Crack it? Yeah. Apparently, they say that he used the $350 to buy that. Please don't put any drug names in the chat. Please be very mindful of what you put in the chat today, being that both of my streams yesterday were shadow banned and demonetized, and the AI program on YouTube is insane. So that was, he was convicted in May of 2007. There were a lot of conflicting witness testimonies, some of which said that they saw a black man at the gas station, but that he had hair. And Dennis Bateman, if you looked at my thumbnail, you will see that he is fully bald. Here's a picture of Dennis Bateman. Hang on. Now, he does say that he was at the gas station because his car was burning oil, or he had a van that was burning oil. And so he does admit that he was there. He was not there at the time that Brandy died. He says he went there. He talked to Brandy. Brandy was his friend, that he needed some cash or some change or something. And Brandy said, go in my purse and get it. And he did. And then he left. And then there's some conflicting witness statements about the description of the defendant. This is Dennis Bateman in cuffs. And he has sworn his innocence since his conviction in 2007. He had another appeal that was decided in 2023 where they upheld his conviction. And in 2019, he had moved for a new trial. That was denied by the trial court. It went up to the SJC, arguing that the 2007 trial was riddled with errors, and cited several decisions by the Superior Court Judge John Agostini as reasons for overturning his convictions. And the SJC rendered in 2023 a 60-page decision. I know it cleared up. They cleared up the sound on Montgomery. Yes, thank you, thank you. And so we're gonna look at that one after this one. A 60-page decision saying that they saw no reason to set aside the verdict or to order a new trial. And so now, based on new information, including the fact that the defense says that these audio tapes, the recorded statements of Dennis Bateman, were altered by the SJC, that he should get a new trial. And also because the jailhouse snitches that testified at the trial were promised things that I think were not revealed to the defense, if I recall correctly. The Bateman case is in, hold on. It's in Deerfield. Is that Hampshire County? I mean, right now it's in the appeals court. I don't know why I'm thinking that it was Hampshire County, but hold on a second. Northampton? Hampshire County, Hampshire Superior Court. That is the same county in which Brian Camp was tried, and that is why Steve Gagne is arguing this for the Commonwealth. All right. But when you hear the attitudes of the judges on the SJC, which is the highest appellate court in Massachusetts, it might give you a little bit more insight into why these things are happening. And without further ado, let us go to yesterday's arguments in front of the SJC. It is about 45 minutes long. As usual, I am going to stop and discuss as we go along. If that is something that upsets you, you are free to leave. This is not an airport. You do not need to announce your departure. But please don't tell me not to stop it, because that's what I do. It's called legal analysis for a reason. All right. This is yesterday's SJC arguments in front of the highest court in Massachusetts, Commonwealth versus Dennis Bateman. If the audio is low, on the court feed, let me know and I will boost the audio because I can do that. And there's a banner. So if anybody comes in and says, what are we talking about? It's going to be scrolling along the bottom. You can direct them there. See? See the banner? See what I do for you? All right, here we go.
Okay, Attorney Codagnon.
May it please the court, Amy Cottignon on behalf of Mr. Dennis Bateman. We're here today.
Right.
SJC 10079, Commonwealth versus Dennis Bateman.
Okay, Attorney Codagnon.
Good morning. May it please the court, Amy Cottignon on behalf of Mr. Dennis Bateman. We're here today, and I'm asking that this court reverse Mr. Bateman's conviction and grant him a new trial. We're here on a second time in 33E review. He had a motion for a new trial that was pending during the initial direct appeal that was heard before this court. And in that direct appeal decision, this court found a number of different errors stemming from withheld evidence, withheld promises, rewards, or inducements, jury instruction errors, closing argument errors. And the court did not find sufficient evidence at that time to reverse. Here today, we have 3 additional issues, each of which I suggest on their own should be enough for reversal. But I'm asking that this court really and truly consider how different this trial looks when you have this new evidence, when you have this withheld evidence, and when you have this witness who the motion judge found there's no reasonable strategic reason for not calling a witness, and if believed, would support Mr. Bateman's claim of actual innocence.
So, quick question about the concern about the audio tapes and whether or not there was an issue with them.
Yes.
Is that actually newly discovered evidence?
Okay, if your mind was wandering, come back to earth now because listen up. Take that back.
Concern about the audio tapes and whether or not there was an issue with them.
Yes.
Is that actually newly discovered evidence? Shouldn't that have been something that was brought in the first motion for a new trial?
It was, Judge. It was brought in the first motion for a new trial. And if I could just
Go ahead,
clarify the record,
please.
because the motion judge, I would suggest to this court, made a mistake in terms of its decision that this was not newly discovered. The court did find that this was not available to Mr. Bateman at the time of trial, that the evidence, the technology has advanced such that it was newly available. But at the time of the first filing of the motion for new trial, represented by separate counsel, the motion for new trial was filed. There was also a motion for funds that was filed for the expert. And of course, this court knows that defense counsel can't raise claims without evidence to support it. So counsel was seeking the evidence to support it. And he kept the court up to date on his progress in that regard. So certainly the motion for new trial progressed. There was an evidentiary hearing on some of the claims that had been granted. But the court, and these emails are within the record appendix, the court had reached out to counsel and said, what additional information do I need to decide the motion? Counsel said, this expert report is forthcoming. And as soon as he got it, I think it's the same day, he filed a supplement to the motion for new trial, adding that issue in before the decision. So that issue was raised as soon as it was viable, as soon as the report was completed, and as soon as it was done prior to the decision on the first motion.
What difference does it make? What is it that you say was problematic with it, and how would it have made a difference in the?
Sure, Judge. So there's a number of different issues there in terms of what was wrong with it. So I think starting at the outset, the officer who is the person who records the interview and is said to have uploaded it, filed an affidavit saying that he recorded this with a digital recorder and then he uploaded it straight to the computer, made no edits.
I don't mean the
alterations.
technical issues. I mean like the actual substantive issue. What is the thing that makes it exculpatory or helpful to?
So that's what I'm getting to, Your Honor. It was modified in multiple different ways, and there's proof from 2 experts with a combined 80 years of experience of intentional editing of the audio recorded statement.
What was left out?
Overstatement.
That is an overstatement, isn't it?
I don't believe it is.
Listen to them. The audio was edited. Who cares? What difference does it make? What difference does it make? I'm going to let you hear that again.
So that's what I'm getting to, Your Honor. It was modified in multiple different ways, and there's proof from 2 experts with a combined 80 years of experience of intentional editing of the audio recorded statement.
What was left out?
Overstatement.
That is an overstatement, isn't it?
I don't believe it is, taking the
It's
expert's own words.
inconclusive. They're not sure what happened.
Why don't you just tell us the record page where we'll find the statement from an expert saying they were deliberately modified?
Sure. In my reply brief, and I'm trying to look right now in my notes, in my reply brief, I know that
I'm going to look for that page while you tell us what it is. So
Just that one moment, Your Honor. Each of the experts gave multiple different statements regarding that they could come up with no explanation aside from intentional editing.
that's something different. That might be their incapacity to come up with an alternative rather than an affirmative statement of,
Sure.
okay,
So on volume 2 of the evidentiary hearing, page 147, the expert said that one looks like an edit.
page what? Sorry, I'm going to look it up.
Sure.
What was the page?
Volume 2 of the evidentiary hearing, page 147. Volume 1, 155, to me, they look like edits. 156, this one looks like an edit to me. This one looks like a pause or an edit. This
Okay, so,
looks like a pause or an edit.
and that's flatly inconsistent with the explanation for how the recording was made, because I didn't see that.
So it is, and that's the issue here, because the explanation is that it was recorded on a digital device and it was immediately uploaded to the computer. And what we know based upon what we have, so starting just sort of at the outset, the moment that this is uploaded into the computer, there are 9 iterations of this document, each of which have different hash values, which means they are not identical files. If he had plugged it in and uploaded it in the manner in which he says he did, there would be 1 or maybe 2 files because there's a bathroom break. They would have naming consistent with the machine, which begins with a letter A, B, C, or D. None of those exist. And the metadata would have the date of the event of recording, which is 4/20/2005. The metadata doesn't match. The names don't match. The hash values don't match. And there's multiple versions of it that are either combined or spliced, renamed, different things are happening, right? So we know that what he says happened didn't happen because it couldn't have happened. That's what the experts sort of explain. And then there's, other things here that are,
The experts say it couldn't have happened.
well, they say that if it had happened that way, we would have metadata that would match. We would have one file name that's consistent with the machine.
I know what you just said. I want your record support for that statement.
I know what you just said, but we just don't care. Hash values. We're all hash value experts now, right? They don't care if the evidence is altered. They just don't care. Is it me? Am I overreacting to this?
For which statement, Your Honor?
Each of the statements, you're saying, I think, your claim is that the experts are saying that the taped interview of your client was modified.
Yes.
Okay. And so I'm wondering where the record support is for that. Is that the volume 2 at 147?
So Judge, there's,
Volume 1 at 155?
that is where they're talking about the evidence of edit. Breaks in the recording are some of those that I've just cited. This was a 2-day evidentiary hearing where we went through all of the different things. So the metadata and the file naming and the hash values and what the recording device is capable of producing and what it in fact did produce here, which was an overloaded sound. We went over how there's an electronic network frequency that is a 50 hertz hum that is present in all recordings that
So
occur.
I understand the technical aspects, at least as far as that goes. I'm wondering where the experts draw the conclusion that this means that the tape or whatever was produced was modified.
So Judge, there's throughout their testimony,
So you don't have a specific site, it's just a generally.
I just named some of the sites for the court where they say, this looks like an edit, this looks like an edit. And each of them at the outset at the conclusion of their testimony said that they could not come to the conclusion that this was an authentic original recording.
That's a negative.
That is, so I do have a technical question about the original recording. The original recording, I thought, and you know the record better than I do, is the Olympus device.
It was the VN2100 machine.
The Olympus?
Yes.
Yes, thank you. And that was uploaded, right?
Yes.
So whatever is on the computer is no longer original, correct?
So what the experts testified to was that what was on the device itself would be uploaded and it would contain the metadata of the original recording.
But what was uploaded is no longer an original. There's been a transfer.
There's
as
been
I
a
understand.
transfer, correct?
Okay. So I guess given that it's an acknowledged transfer, I'm not sure why the fact that it's not original, which seems like it's undisputed, should matter in terms of
Wow.
your client's position or the
Wow. I don't know why metadata should matter. At least they're all on the same page. Did they have a conference on this? Metadata, not important. Don't worry about it. No big whoop. No biggie. We don't need the original of anything. First year of law school, you take an evidence class. It's the best evidence rule. It's black letter law. Use the best evidence that you have. An altered recording is not the best evidence.
expert's position, I guess, that there's been definitely a modification of the recording.
And that's why it matters, because they're holding this out to be an authentic original recording. And based upon,
But no, I mean, I thought it was acknowledged that the original is on the Olympus. At some point, the officer uploaded it to the computer.
sure, and
And at a second point, it was downloaded to
CD. or
compact disc.
and the hash value.
So
should be
whatever is on the compact disc would certainly not be the original Olympus recording.
No, but it shouldn't have signs of editing.
It shouldn't have signs of editing.
And it should have,
And that's on page volume 2, 147, volume 1, 155, and 156.
so Your Honor, I mean, there's two days of testimony that talk about, so the hash values is one of the things that I'm pointing to for how we know that there was modification made to it after the date of the interview.
And the hash value modifications are inconsistent with the admitted uploading to the
Yes.
computer and downloading to a CD.
Yes.
Okay, and that's where in the record?
If you could give me just one moment.
Sure, thank you.
On volume 2, page 11, there's testimony that the hash values of the duplicates provided by the police differed.
Where is the conclusion that the fact that the hash values differ means it's been modified?
So I mean, the conclusions were at the end of the testimony, and I can get those pages for the court, but what we did was we went through all of the different things to try to determine whether or not there was an issue here. So first of all, trying to figure out what the recording device was consistent with, looking at the hash values, looking at
I
the
don't
metadata,
need you to
looking at
go over
file
the
naming.
technical aspects of this. I think I quite clearly understand. What I want to know is where the experts articulated their conclusion as a result of all the hash values and the metadata being different and blah, blah, blah. It is modified.
So I think what they said was not, it was modified, it's that that you would expect it to be the same. So and I don't have every single site here at my fingertips, but I did file a very lengthy memorandum after the hearing that's in the record appendix that went through each of these topics and how both of these experts, and sometimes the Commonwealth's expert concurred with these on each of these topics. So the hash values, the metadata, the file recording. And what we have here is, there's announced start and stop times for the first part of the recording. He, at 1:30 into the recording, he says it's 12:09 p.m.
What has been changed?
So, and that's what I'm getting to, Your Honor. So he says it's 12:09 p.m., so we can infer based on a minute and 30 of that into the recording that it's 12:07.
What does your client say has been changed? This was his interview, right?
Yes, Your Honor.
What does he say has been omitted or changed?
So what I'm trying to explain to the court is that there's a number of minutes that are missing from this audio recording, just based upon their announced start and stop times. It should be an hour and 12-minute recording, and it's 58 minutes based on what the police say the time is when they start and what the police say the time is when they stop, right?
Did your client submit an affidavit saying what occurred during the missing time?
He did not.
Oh, Mastat, is this Judge Dewar? Because I just looked up her pictures, which are a little bit old, but I think maybe this is Judge Dewar, the one who just denied Kelsey's bail petition. There are 14 minutes missing from this recording, kind of like all that missing Sallyport video that didn't seem to give grave concerns to Judge Cannoni either. Oh, this is Judge Wolo. I'm not even going to try and pronounce that. Okay, when you see Judge Dewar come up, can you tell us? Thank you. Because I can't see their nameplates. No grave concerns about 14 minutes.
What the police say the time is when they stop, right?
Did your client submit an affidavit saying what occurred during the missing time?
He did not specifically.
Okay, so how are we supposed to hypothesize what may be missing in these 12 minutes?
I don't think the court needs to hypothesize.
Well, don't we, in order to find out whether there's been a miscarriage of justice in the conviction?
So I think the court needs to look at a few things here. The first of all is that when we're talking about destruction of evidence, which is what we're talking about here, it's a
Well, none of your witnesses testified to the destruction of evidence.
testified to edits, Your Honor.
Okay. The trial was in 2007, 18 years ago. Don't you think the jury deserves to know that it's not the original recording, that the recording was edited, and let the jury make the determination on whether that's a miscarriage of justice? Do we need an affidavit from the defendant who must say, oh, here's what I told them. Here's what's not in the recording, because he's got a Fifth Amendment right not to testify. Am I missing something? I'm not a judge. I'm not a constitutional scholar by any means. But the defendant does not have the obligation to say anything. It is the Commonwealth's burden to prove guilt beyond a reasonable doubt. It's insane. Here you go. Let's hear that again.
Evidence, which is what we're talking about here. The first of all is that when we're talking about destruction of evidence, which is what we're talking about here, it's a
Well, none of your witnesses testified to the destruction of
They
evidence.
testified to edits, Your Honor, edits. And
Well,
we have minutes of this missing
Right.
that are, of this recording that are missing.
And how does that cast real doubt on the justice of the conviction, which I think is the test that we articulate? I'm sorry to ask you these questions, but you're here to answer our
No,
questions.
I understand,
And you
Judge, but
seem very upset that we're
I-
asking you questions.
No,
My question.
Okay, I'm sorry. What? You seem very upset that we're asking you questions? You know, there's a special place in hell for women who publicly denigrate other women and women who get out there and troll other women and attack other. There's a special place in hell for those women. I'm not saying anything about this woman in particular, but I find this to be unnecessary and gross, quite frankly. Let's listen to it again.
I think is the test that we articulate. I'm the justice of the conviction, which I think is the test that we articulate. I'm sorry to ask you these questions, but you're here to answer our
No,
questions.
I understand,
And you
Judge, but
seem very upset that we're
I-
asking you questions.
no,
My question is, I'm trying to apply the legal standard for newly discovered evidence.
Sure.
Assuming it's newly discovered, the question on prejudice is how does it cast doubt on the justice of the conviction? And in the absence of an affidavit from your client saying, I said something else, that's missing. What is your position as to how this casts real doubt
So-
on the justice of the conviction?
There's two things that I really want to make these points, because I want to take a step back from what's
Go
missing,
ahead.
So Mr. Bateman, before his trial, a month before his trial, said to the court, he's represented by counsel, but he feels compelled to get up and say, this transcript of my testimony is not right. I need these audio files because the transcript is wrong. This is not what I said to the police.
And he
He's
says,
saying this-
what's missing? What did he say?
He didn't articulate exactly what was missing, but if you look at the defense, that the Commonwealth proffered and the defense proffered, they're only talking about Mr. Bateman's words. So they're talking about the Commonwealth, I think, seven
Well,
different
it's not-
times,
It's not just his words. His DNA is on the belt.
which
There,
he
there are
admitted to
4 or
touching.
5 people who see him there at the proper time. There's, as
but-
we said the first time around, there's overwhelming evidence here. So the fact that there's some missing pieces to his interview without identifying what's important, so what?
So this is the point that I was trying.
So what? So what? He probably did it. So what? Eyewitness testimony is the least reliable form of evidence. The least reliable form of evidence. Ask anyone who has ever watched My Cousin Vinny. I think, no, there was no hearing regarding Kelsey's denial. Andrea, rewind to the beginning of the stream. And it was just issued and I went over it at the beginning of the stream. But I didn't have a chance to change the title because it broke right after I went live. So what? I think we need a t-shirt. So what? Says the SJC of Massachusetts. So what? He probably did it. Bunch of people saw him there. They saw a black man with hair. He's bald. So what? We probably got the right guy. No big whoop. No biggie. If this doesn't outrage you, I mean, in addition to all of the other things about Massachusetts that may outrage you, and many of you live there, there are 4 or 5 people who see him there at the proper time. Take that back.
He
There are
admitted to
4 or
touching.
5 people who see him there at the proper time. There's, as
but-
we said the first time around, there's overwhelming evidence here. So the fact that there's some missing pieces to his interview without identifying what's important, so what?
So this is the point that I was trying to make. So what? You've got evidence that the police are deliberately manipulating evidence.
Does
So-
anyone, you got to be more careful. Does any of your experts say that? Because that's a really serious charge to put on a police officer when your experts are talking in negatives. They can't conclude based on this. You got to be careful or you're going to get in trouble.
And I'm going to add something to that.
Wow. Spanking an attorney who's doing an excellent job, by the way. Her name is Amy Cotignon. You better watch out. How dare you? We have a how dare you emoji. How dare you accuse the police of doing anything nefarious? How dare you? I'm sorry. Did these judges, do they sit too high up to have paid attention to the Karen Reed's season 1 and 2 and the inverted Sallyport video and the video that just went missing and disappeared? And that happened in 2022, 23, and 24. So who knows what was going on in 2007? You better be very careful, Missy. You better not make allegations like that, Missy, or you're going to be in trouble. And listen to the other gentleman. You could hear him before when this judge was speaking. He was like, uh-huh. He's in the background. We haven't seen his face yet, but he's going, uh-huh. You better be very careful, Missy. How dare you accuse the police of doing anything wrong? Boy, let's hear this again.
You got to be more careful. Does any of your experts say that? Because that's a really serious charge to put on a police officer when your experts are talking in negatives. They can't conclude based on this. You got to be careful or you're going to get in trouble.
And I'm going to add something to that because there's even more to that. Is your experts say some of the things that you say is wrong with the recording of Mr. Bateman's is consistent along all of the testimony, all of the recordings. There's all of this background stuff. So if we're still under the general kind of constraint of an abuse of discretion standard, back to how are you saying this really powerful affirmative statement that this is what they did?
I'm going to take this back. Okay, so it's Judge Dewar, the one on the far left who denied Kelsey's petition. Let's take it back to the full judge screen. Hold on, I'll freeze it when we get there.
What you got to be more careful. Does any of your experts say that? Because that's a really serious charge to put on a police officer when your experts are talking in negatives. They can't conclude based on this. You got to be careful or you're going to get in trouble.
And I'm going to add something to that because there's even more to that.
Okay, so here it is, all the way on the left here. That is my cursor on your screen. This is Judge Dewar. She is the one who just denied Kelsey's appeal.
Is your experts say some of the things that you say is wrong with the recording of Mr. Bateman's is consistent along all of the testimony, all of the recordings. There's all of this background stuff. So if we're still under the general kind of constraint of the abuse of discretion standard, back to how are you saying this really powerful affirmative statement that this is...
I'm wrong again. She's further left, out of frame. Okay. Okay, I'm not going to identify her anymore because I keep getting it wrong. So anyway, she's on the panel. She's apparently full left, all the way on the left. But I didn't see any other seats to the left. I saw an empty seat. All right, what else?
What they did.
So, and this is how, Your Honor, and I want to make this point that if you're cross-examining the detective who's saying, I just plugged this into the machine, and there's multiple different ways that we can show that that's not what happened, including the 9 iterations of this recording that are uploaded at the same time, that's exculpatory because it's impeaching this officer who's claiming something happened, and we know it didn't happen that way. And this officer is connected to every different part of this investigation. He's connected to these informant witnesses. He's connected to, not asking certain questions of witnesses and not investigating leads and all of these things. So that's why it makes a difference, because we're talking a lot about his statement. And in Mr. Bateman's recording, we have an explanation as to how the experts believe that this happened. And that's going back to the ENF, the electronic network frequency. There's this hum that should exist at 50 hertz across the entire recording. And there's breaks in that hum, which are signs, and they testify to this, that they can explain no other way aside from intentional editing. They've looked at every other explanation. There's no other explanation that they can come up with. But beyond that, there's
volume 2,
mirrored hum.
147 or volume 1, 155. Are we going to get that quote, or are we going to get, I can't make sense of this, or I don't understand how this happened? It's just, they're qualified, I believe, but I haven't read through this whole transcript, but I'm certainly going to.
And yes, Your Honor, I think that you will see exactly that.
You're going to see quotes saying, I conclude that they deliberately.
No.
Of course not.
We can't say what they did or that they deliberately or didn't, but they will say, this looks like an edit. I can explain this no other way aside from
What does an edit mean? It means
a break in the recording.
Yeah, okay, but a break in the recording, there are lots of reasons why you have breaks in the recording that aren't malicious.
Well, so Judge, I think that they looked at that, right? They looked at, is there an explanation for this? Was there pausing? And that's not what the officer said
Let's shift
happened.
you to the next issue. So the witness, we have 2 other witnesses. One witness that Jubinville, the lawyer, doesn't call, is late to her dinner, and she doesn't see the truck. We have 4 other people who see this very distinctive van with, so again, how's that going to create a substantial risk of a miscarriage of justice?
Yes, Your Honor. So it's going to create a substantial risk of a miscarriage of justice because Mr. Bateman admitted that he was at the gas station earlier in the day. You have multiple witnesses that talk throughout the day of having been by the gas station. Some are at 5 o'clock, 5:30, different times like that. Mr. Bateman says that he had left and that he was in downtown Greenfield. We have a witness who in her original testimony puts him downtown at 6:45. You have, and that's exculpatory.
We have a bunch of witnesses who put him there at the right time.
So I disagree with that, Your Honor, because first of all, the descriptions
How many witnesses place him there? I can't remember, it's 6:30, 6:40 time period.
There's one person who says there's a blue van there at 6:24. That's the closest the Commonwealth can get, except for Mr. Williams, who says that he drives by at 6:30 p.m., the exact time that this witness says she's in the parking lot. and that
Is
he sees the
is he
van
the
there.
person who sold him the paint? There's this person.
Yes.
So the person who sells him the paint sees the van at the right time.
Mhm.
And because this woman who's late for her dinner and is not really paying much attention misses this, this is a reversible error.
No, Judge, because I think that you're making a credibility determination that's for the jury to make.
I'm not
So this
making-
person.
I'm not making, I've got multiple witnesses and I have one witness who just doesn't remember it. And her testimony isn't it wasn't there. It's I don't recall it's there, right?
So what she says, Your Honor, is that there was a shiny red pickup truck parked out front. She says she does not recall seeing a van. And the court reconciles this with Mr. Williams' testimony by saying that Mr. Williams himself actually wasn't certain about the time. So it's possible that Mr. Williams actually drove by earlier. But what the court misses is that when she drives by, she's certain about the time because she's late for a reservation. It's 6:30. She's supposed to be at the Deerfield Inn at 6:30. She gets there at 6:32. She's confident about the time. She doesn't see a van. She sees a shiny red pickup truck, which the police do not investigate. And she sees two people inside of the gas station standing up, which means the way in which the court reconciles.
Oh, they did not investigate the shiny red pickup truck. Does that sound familiar to you? About the police like not investigating a Ford Edge? Same dog's old tricks.
She doesn't see a van. She sees a shiny red pickup truck, which the police do not investigate. And she sees two people inside of the gas station standing up, which means the way in which the court reconciles the difference between Williams and Allison Hamilton is to say that Mr. Bateman had already.
But there's one other thing though. You're under, all of this is under the umbrella of your IAC claim. And at the beginning, when you started your presentation, you said that no reasonably fallible lawyer would have not called her. And there's a letter in the record, right, where there's an explanation from the lawyer to Mr. Bateman about why he doesn't think that it makes sense to do this.
So that's actually from prior appellate counsel. It's not from trial counsel.
Well, the issue is whether or not it made sense to do this, whether it was going to, and so we have the trial judge's findings saying there is a way to reconcile this. And so we're still under what the trial judge did with this issue and saying it's not the silver bullet that you're saying that it is.
The trial judge actually found that there is no strategic reason. He just found the prejudice issue.
Right.
So,
We're still under that conclusion.
well, but I think that this is a question for the jury to resolve because this is the critical time. Whether or not he was there earlier, she was alive. When Allison Hamilton drove into the parking lot, she was alive and inside the gas station standing with somebody, and there's a red pickup truck there, not a van. So that's a Bowden defense. That's a police failure to investigate, but it's also evidence, if credited by the jury, that Mr. Bateman is actually innocent, that consistent with what he told the police, he's downtown. He's not there any longer. So when you have all of these descriptions of different people that are saying, there was a black man with curly hair, Mr. Bateman's bald, you know, different weights, different heights, different color vans, and everybody's just sort of muddling this together to say, oh, well, it was Mr. Bateman. But we have a witness who says at the time of death, because at 6:33 p.m., Leonard Mazzone pulls in, and at that point, she is dead. We know she's dead. Nobody else goes into the building. So that's the critical time at 6:33 p.m. And if the jury believes her, if the jury believes that this person in the shiny red pickup truck is standing inside the gas station with her at 6:30 p.m. and she's confident in that time, that would have been the last person to have access to her before she was killed, not Mr. Bateman, if the jury believed her. That's why it's important.
But we still have to weigh that against all of the other evidence of his guilt.
I think the jury needs to weigh that. That's
Why does the jury need to weigh that? We have this argument come up. We've had this argument come up but several times recently. This is a motion for new trial. Doesn't the motion judge need to make an assessment of the weight or the value or the quality of what it is that the defendant is now seeking to have a new trial
sure.
with? Okay.
And shouldn't the jury get to weigh whether or not the defendant's own statements, the recordings of his statements, were edited and or altered and or proctored, doctored to tullied or sullied? Shouldn't the jury get to consider that as well? I don't know, just spitballing here. Somebody asked who the officer was. The officer's name was Mark Whalen. That was the officer who did the interview of Dennis Bateman, or interviews that were allegedly altered, edited, tullied, sullied, proctored, and doctored.
Okay, so it doesn't look to me like the first question is, what would the jury do with this? It looks to me like the judge needs to evaluate, I have no other word for it than the weight or the quality of what it is that you're proffering to determine whether that meets the threshold for a new trial. Would you agree with that statement of the law?
That's
Okay,
why we
then
should
let's
have evidentiary
follow up.
hearings.
Well, he did have an evidentiary
Not on this
hearing,
issue.
not on this one. So but here, isn't there like a chronology problem for you? Because even if we accept this witness's statement, it's about what she saw at 6:30. We have a dated time of death at 6:33. A disinterested and good percipient witness's statement that he recognized the van and the person at 6:24. This is a 9-minute gap, right? And a whole death occurs in there. And don't we have some kind of, maybe, I want to say, diminished value to a momentary spotting in that period that almost doesn't leave time for the death to occur and is inconsistent with what everyone else saw? Like, why can't the judge look at that and say, that's really not worth having a new trial over?
So
Wow.
I think that
I don't
typically
know,
judges can
maybe
make that
because an
decision.
innocent man might be in prison since 2007. Is that a good enough reason? Do you recognize a lot of these judges from Karen Reed's appeal? I do. Is that a good enough reason that maybe there's an innocent man sitting in prison since 2007? I don't know. Just tossing it out there. They don't seem to care. Take that back a second. She was strangled with her belt. He admitted to touching her belt. He also admitted to touching her and going into her purse to get change, which could explain his DNA, which I guess was skin cell DNA underneath his fingernails.
Almost doesn't leave time for the death to occur and is inconsistent with what everyone else saw. Like, why can't the judge look at that and say, that's really not worth having a new trial over?
Worth it.
So I think that typically judges can make that decision. There's a few things, though, that I want to point out about the 624 witness. He doesn't recognize the defendant. He doesn't recognize the van. He says it's a blue van that he sees, right? So it's not as strong, I think, as if you actually look at that testimony, it's not as strong as some might believe. But what the court did here is tried to reconcile David Williams, who's the 6:30 p.m. drive-by, tried to reconcile that with Allison Hamilton. And what he did was he said, well, he could have been wrong about the time, and maybe the jury's going to discount him at the time, and maybe he actually drove by earlier. And that allows Allison Hamilton to drive through and then not see the van because the van's already gone. But what the court ignored is that she sees two people standing inside. So the court's sort of making this determination, oh, maybe David Williams, who was a critical witness, if you look at the Commonwealth's arguments, critical witness for the Commonwealth, maybe he wasn't actually right. So he's resolving some sort of discrepancies there without letting the jury determine, is he believable or is she? And that's the question. Is he saying, well, it's possible that the jury could have reconciled these in a way in which is not exculpatory. But here, I mean, where you have something this critical, this key, in a case where, it's a homicide case, Mr. Bateman is serving a life sentence, and you have a witness who really, if believed, shows that.
Was there any forensic evidence to suggest there was a second killer?
Yeah, there's 59 fingerprints inside the gas station that are not identified. There's other DNA profiles, mixed DNA profiles on the strap itself. And There's other.
I need to correct something I said before because Mark Whalen was a witness. He's not the officer. I have to go back and find the officer's name in this 105-page brief. So Mark Whalen was a witness.
DNA that wasn't tested. There's saliva on her ear. There's a whole slew of other DNA that has not been tested. So there is other forensic evidence that
Is there
exists. There's
anybody else's DNA who's under her fingernails?
No, Judge. Not that I'm aware of. No, Judge.
Or anyone else's DNA that was located on her? In other words, it was not tested, but was there anything that was on her that came up with some other person's
There's no profile
DNA
that's generated
profile?
from a person that I'm aware of, Your Honor. The testing was focused on the belt, which is multiple profiles. There's inclusions of Mr. Bateman and another person, Anthony Cox, who has some suspicious behavior. There's footprints that are not attributable within the gas station to Mr. Bateman. Nobody determines whose footprints those are. There's 59 fingerprints that are unidentified. There's other forensics that could suggest that somebody else was there. And there's leads that weren't investigated. The shiny red pickup truck, the woman that Mr. Mazzone sees driving away when he pulls in at 6:33 p.m. There is evidence that's consistent with Mr. Bateman's innocence that frankly, some of the jury did hear, but this new evidence the jury did not hear. I think that I'm far over my time, and for the remaining issues, I'd rest on my brief. Thank you.
Barbara says, why would Bateman have touched the belt or gone into her purse? They were friends. He went into the gas station. Maybe he hugged her, touched her belt. He said he needed to borrow some money. She said, just go in my purse and get it. It's all in the briefs. And apparently there's some other DNA, including some guy named Anthony Cox's DNA. Other leads that they failed to follow. Sounds familiar, right? Okay, moving on. Let's hear Steve Gagney now for the Commonwealth.
Okay, Attorney Gagney.
Good morning, Your Honors. May it please the Court, Stephen Gagney on behalf of the Commonwealth. Your Honors, I'd like to start with just two foundational frameworks through which this Court should assess the motion for new trial. The first is that it's beyond dispute that the evidence of the defendant's guilt in this case was overwhelming. That was a finding by this Court 2 years ago in the decision on the defendant's direct appeal. That was found by the motion judge in denying the motion for new trial, and none of the issues raised in the current appeal obviate the fact that the defendant's DNA and his DNA alone was found on the ligature used to strangle the victim to death. None of these issues touch upon the DNA of the defendant being underneath her fingernails, and none of these issues take away the
Why is
defendant's
this not
written.
newly discovered evidence, the expert findings of anomalies on the recordings?
For two reasons, Your Honor. First, the motion judge, the trial judge, found that this issue could have been discovered.
Right, so the defendant tried to add that to the motion for a new trial too and was denied.
Exceptionally belatedly. And the reason I say that is because the motion for new
But counsel just represented that it was on the day after they received the expert report, which was the first time that they could actually raise it.
That's inaccurate, I'd suggest, Your Honor. And here's my chronology, and I think the record bears this out. The defendant filed his motion for new trial on August 31st of 2018. It was remanded to the Superior Court. The defendant then, with the court's allowance, amended and supplemented the motion on October 4th, 2018. The court then set aside 2 full days of court time to have a full evidentiary hearing on that motion, May 30th and 31st of 2019, and then took the matter under advisement. Now, in the background, the defense is working and trying to develop another issue, but it's not until August 21st of 2019, after the motion's been under advisement for 3 months after the hearing, and a mere 9 days before Judge Agostini issued his denial, that the defense attempted to what they call supplement, but really it was the insertion of this entirely new ground. And Judge Agostini, specifically in the footnote to his motion, said, for the reasons stated by the Commonwealth.
When did the defendant get funding for the experts?
Well, I think the judge here was trying to strike a balance between not completely handcuffing the defense of exploring potentially.
You don't know when the defendant got funding for the experts?
Pardon me?
You don't know when the defendant got funding for the experts? I can look it up.
Oh, it was throughout 2018 and 19, I believe.
Okay.
And it continued on even after the motion had been denied. But the judge specifically said, for the reasons stated in the Commonwealth's motion to strike, this is late. I'm 9 days away from issuing my decision, and this is the latest in a long string of interminable litigation in this case. So the judge, I think, was trying to strike a balance of, again, letting them explore issues, but also trying to move this case along. The judge also found that there were sufficient technologies and softwares available well prior to the motion for new trial being filed where this issue could have been raised. Much of the software and the programming that the experts in this case used, they admitted during the hearing that it was available in 2007, 2008. There were updates and software upgrades throughout the years. But the experts also said that their most important tool is the human ear. It's critical listening. And they could have done this even before trial. There was a representation in the defense brief that the audio recordings weren't turned over until a month before trial. I'd suggest the record belies that claim. The defendant was arguing that he wanted copies of the audio recordings a month before the trial, but defense counsel already had them. And for that reason, the judge found that this truly isn't newly discovered. It could have been raised, if not at the time of trial, well before the motion for new trial in 2018. But even if we get beyond a potential...
I'm sorry, but his voice gives me PTSD from the Brian Camp trial. Metadata doesn't matter. Just listen to it. You could tell if it's edited. Is that really what he just said?
Potential waiver issue or this not being newly discovered, the trial judge was well within his discretion in finding that these experts really weren't giving him anything conclusive. There was talk about anomalies of unknown source or origin, something as innocuous as the sound of typing in an office. One of the experts chalked up to an anomaly.
How about the two she brings up in the first part? Volume 2, 147, Volume 1, 155. What do they actually say there? Do they say that this is evidence of editing, or do they have sort of a more nuanced description of this?
It's always phrased in terms of possible editing or consistent with, could be, but can't rule out other causes. And on the issue of intentionality, which the court spent much time on this morning, I'd like to direct the court to some very specific passages from Volume 1, that being April 18th of 2024, when expert Lindsay Hawk was testifying. On page 53, lines 12 through 16, she said the following: all of the things that we're talking about here could signify deliberate or indeliberate editing. We're not trying to characterize them by telling you something that we can't know because we weren't there, but these are artifacts that could signify some kind of change in the recording. 2 pages later, page 55, lines 1 through 7, the witness is asked, based on your training and experience, can you opine whether intentional editing happened? Answer: that's a tough question. I mean, editing seems to have happened. Intentional is a step that I think an analyst isn't really capable of attributing. It could be non-accidental, but intentional is, not a word I would use. And then last,
I don't think that any expert could say that it is intentional. That is a question for the jury in deciding whether or not a witness is credible. So that's kind of a hollow argument to me. I don't think any expert would risk their entire livelihood and career to say that it was done intentionally. It was edited. Isn't that all we need to know?
lastly, on page 101, the same expert, Lindsay Hawk, when asked kind of the wrap-up home run question by defense counsel, she was asked, you can tell us that based upon the sheer number of anomalies in Mr. Bateman's interview that it's consistent with redaction and possible active editing, right? And the witness replies, I think it's fair to say that we can't say for sure that it didn't happen, which is relevant. I think it was like trying to nail Jell-O to a wall in this case. And when you look at the judge having an evidentiary hearing.
Trying to nail Jell-O to a wall? Like you nailed the defendant to the wall where he's sitting with a life sentence or two? I think 2 life sentences since 2007 when he may in fact be innocent. Maybe that's nailing Jell-O to the wall. Gagney.
That it didn't happen, which is relevant. I think it was like trying to nail Jell-O to a wall in this case. And when you look at the judge having an evidentiary hearing, letting this evidence come out, analyzing it as he was there on the front lines, he'd observed the witnesses, listened to he credited their testimony. He credited it in the sense that he didn't dispute that they were experts and that they had some experience in their field, but ultimately could be consistent with possible editing,
Can I
intentional
ask
or
you to
unintentional.
address the ineffective assistance of counsel claim? Why not call Allison Hamilton? And assuming it was poor lawyering, why is that not prejudicial to the defendant? Addressing specifically counsel's argument that Allison Hamilton stated that she had seen two people, including the victim, in the convenience store or gas house station.
The motion judge honed in on a couple of different topics, reasons why this was not ineffective. Well, he did say that there's no good strategic reason for not calling her.
Right, so
Judge
moving
said
to the
no-
prejudice.
No prejudice. First and foremost, I think it's really because of what Allison Hamilton did or didn't say. When you look at her statement, and this was echoed by Attorney Nathanson, a prior appellate counsel to Mr. Bateman, Allison Hamilton said there may have been another vehicle parked parallel to the building, but it's hard to say for sure. Allison Hamilton also said, I don't recall seeing a van in the parking lot, but she never affirmatively said there was no van in the parking lot. This was a quick U-turn that she and her husband pulled through the parking lot because they were late for their reservation of the Deerfield Inn. She wasn't taking an inventory of all the vehicles, their make or models. It was a brief encounter. The judge coupled that and compared it with the 6 other witnesses, ranging from 5 p.m. to about 6:30, who all saw this distinctive, awful paint job black van, including the person who'd sold the paint cans to Mr. Bateman to paint the truck, and several of those witnesses, Candace Cohn specifically, Margaret Lone, they had receipts showing that they had paid for their gas at 6:10 and 6:22 p.m. respectively. So I think when the judge looked at not only there's not much substance to what Allison Hamilton said here, and given the parade of witnesses that the Commonwealth called, and the defendant's admission that he was there that day driving that van, admittedly, he didn't say at 6 p.m., but in the grand scheme of things, and particularly the judge said in light of the overwhelming evidence of the defendant's guilt, this would not have made any difference whatsoever. So there was no prejudice from that.
Can you, I'm sorry to make you go back to a previous topic, but could you address the claim that they're missing minutes from the recordings?
Yeah, let's hear that, Steve.
Yes, Your Honor. So it is factually in the record that the original recording would be inside this handheld.
The defendant had a black van, but a witness said that it was a blue van. Some saw a black van. Some said it was shiny. I think his wasn't shiny, if I recall. Let's hear him talk about the missing video, because Christia Painter's daughter points out intentional is hiding it in a drawer, intentionally inverting a video. Say no more.
Digital device that Sergeant recording is factually in the record that the original recording would be inside this handheld digital device that Sergeant Gadro had just started using. It was 2005. I believe it was right on the heels of DGM Batista. The original recording is in the device.
I had one of those little dictaphones. It was a little tape recorder, like, I don't know, like this big. It had little tiny tapes in it. And you just carried it with you, put it on the table, and you hit record. It was like a little tiny dictaphone. I know exactly what he's talking about. Do you guys?
On the heels of DGM Batista, the original recording is in the device. The moment he uploads it to the computer, we're then dealing with a second generation or a version of it. Then it gets downloaded onto a disk provided to defense. So it's already, we're getting it further and further away from the original. Files
But
are
none
getting,
of that would result in missing minutes. Why the missing minutes? What's the explanation? Why doesn't that raise suspicion that these recordings were modified?
Right.
I believe the allegation of missing minutes is that when the officer announces the time at the beginning and the time at the end, we don't know if we're just 1 second past the minute or 59 seconds into the minute. And the difference of up to 2 minutes wouldn't necessarily mean that there was editing or time lost. It's just the officer's recitation as opposed to some
But we
digital.
just heard a representation that there are 11 or 12 minutes.
14. 14 minutes. The entire recording is an hour and 12 minutes. And the defense was only provided with 58 minutes. According to my math, that's 14 minutes. And we've done the work. We know a full conversation can be had in 22 seconds, right? We did it.
Heard a representation that there are 11 or 12 minutes missing.
That's not my recollection that there is an affirmative established chunk of time missing. And when you back up for a moment, when you, again, talking about these anomalies or what was supposedly missing, first of all,
experts describe, how do the experts come to the conclusion that there are missing minutes? I haven't read all through this. How do they discern that?
I think my recollection is that it's based upon.
I haven't read all through this. I haven't read all through this. You have one job, judge, and that is to read and familiarize yourself with the briefs before you walk into oral arguments. But I haven't read all this. No big whoop. Wow. Let's hear that again. Okay?
How do the experts come to the conclusion that there are missing minutes? I haven't read all through this. How do they discern that?
I think my recollection is that it's based upon the officer announcing the time at the beginning and announcing the time at the end, and whether they're looking at the same clock, what type of device it is that they're using. It's an inexact science, so I don't think you can really pinpoint down and conclusively say that time was lost. But in any event, even when you step back and look at this from a little bit broader perspective, let's not forget that on April 18th and April 20th, 2 times Mr. Bateman was interviewed. Not only was there an audio recording, but then the police typed out the statement, he reviewed it, and he signed it. And he had a chance to make changes, to put notes.
Wait a minute, hold the phone. Do you mean that in 2005, Mr. Gagning, the MSP had the ability to record statements of defendants all the way back in 2005? They had the ability? And then he actually had a chance to make changes and sign the statement since 2005, and yet in 2022, it's just not done anymore? Did it become obsolete? What has changed? Hold on. I need to hear that again. None of the witness statements into the investigation, and I use the term loosely, of the murder of John O'Keefe, none of the witness statements were signed. None of them were recorded. None of Karen Reed's statements were recorded. The only statement that the MSP ever recorded was Lucky Loughran, the plow driver. And most of that recording were questions about Turtle Boy. Wow. Let's hear that again.
And even when you step back and look at this from a little bit broader perspective, let's not forget that on April 18th and April 20th, 2 times Mr. Bateman was interviewed. Not only was there an audio recording, but then the police typed out the statement, he reviewed it, and he signed it. And he had a chance to make changes, to put notations in the columns. Even when he was reading his written statement into the recorder, the experts were claiming there were anomalies and cuts and pauses and edits when the words out of his mouth matched up perfectly with the words on the pages, showing that nothing was missing.
And did he sign the statement where he talked about the belt out of nowhere? Is that one of the things he signed, or is that one of the ones he didn't sign?
After his first interview, kind of on the way home, he mentioned it, which is why they invited him back on April 20th.
No.
And that's when he put it both on the recorder and on paper. And returning to your Honor's point, we don't know what supposedly the police cut out here. Mr. Bateman, it's been 20 years since his 18 years since his conviction. We're still guessing at what supposedly exculpatory.
It doesn't matter. I submit to you that it doesn't matter what was cut out. We know you can have a whole conversation in 22 seconds. You tell me that there's 14 minutes missing from these recordings and the jury shouldn't hear about that? Yep, he talked about that belt out of nowhere. Yep, that wasn't recorded. It's in the briefs. We're going to have to do a deeper dive into this before the decision comes out. It could take them 90 days to render a decision, but after I read the briefs, I may have a different opinion, but based on what I've read, he may actually be innocent.
Nuggets, the 15 years the police cut out here. Mr. Point, we don't know what supposedly the police cut out here. Mr. Bateman, it's been 20 years since his 18 years since his conviction. We're still guessing at what supposedly exculpatory nuggets the police edited out in this malicious scheme.
Exculpatory nuggets, malicious scheme. Oh, Gagney, you should choose your words a little more carefully because we were here for 2 seasons of the Karen Reed persecution. And we've also been watching the persecution of Aidan Carney, a journalist who is being railroaded and selectively persecuted for things that are covered under the First Amendment. So when you talk about what nuggets the police might have edited out, you may want to refer back to the inverted video that was shown during season 1 of the Karen Reed trial, in which Yuri Buchanan was asked, is this a fair and accurate representation of the way the Sally Port looked on whatever date it was? And he said, yes, it was. Outright lie. An outright lie. The video was inverted. It was flipped. So when you come in here to the SJC and you start talking about, alleged malicious scheme of the police as if it is something that is completely ridiculous and what alleged nuggets the police edited out. Oh, and maybe you also forget Kelly Dever, who testified, who worked at Canton PD, who said that she saw Higgins and Berkowitz go into the Sally Port for a wildly long time because she was sitting out there watching the monitors. A wildly long time into the Sally Port when Karen Reed's vehicle was in there. And then after she was rehomed to Boston PD and pulled into the commissioner's office, Commissioner Cox, and told to do the right thing, she realized that must have been a false memory. You want to talk about malicious schemes? We've seen the malicious schemes play out. So I'm going to tell you how many views this has, okay? Let's look. Look. Oh, I got to get myself out of the way to show you that these oral arguments right now on the Massachusetts SJC YouTube channel has 59 views. We are view number 59. That's how many people are watching this. In addition to the 3,500 of you that are here right now, this has 59 views. Nobody's paying attention to this. Except for me and now you. We don't know what supposedly the police cut out here. Look, and then it says Mr. B, Mr. Babe. I don't think it means to say Mr. Babe. I don't know what it says. It's supposed to be Mr. Bateman. Right. She said it was a false memory. We've seen this film before. And we didn't like the ending during season 1. The ending was a little bit better during season 2. But there's still a turtle out there to free. And a Kelsey Fitzsimmons to free. And maybe Dennis Bateman to free. Because none of you people seem to think that this is important. Half of the judges are laughing about it. The female attorney, Amy Cotignon, was actually reprimanded twice. Once by a female judge who said, oh, you seem to be getting annoyed that I'm asking you questions or something such as like that. I'm summarizing. And then another male judge who told her, you need to be very careful, Missy. I'm also summarizing, or you're going to get yourself in trouble. Let's see what I rewound it just a tiny bit. We are the 60th view of these arguments, and it's been up for a full 24 hours.
We don't know what supposedly the police cut out here. Mr. Bateman, it's been 20 years since his 18 years since his conviction. We're still guessing at what supposedly exculpatory nuggets the police edited out in this malicious scheme. And there's also no acknowledgement in the defense's brief that the motion judge explicitly credited the affidavit of Sergeant Gadro, finding that there was no shenanigans here. There was nothing nefarious. And as the motion judge,
Shenanigans and nefarious in the same sentence. That's the judge's, the guy's name, Sergeant Gadro. I think it's Gadreau. Like the Gadro brothers, like the hockey brothers. Wait a minute, I got to go check the spelling on that. Shenanigans and nefarious in the same sense. Perfect.
shenanigans here. There was nothing nefarious. And as the motion judge who presided over the trial, that credibility determination should be afforded special deference.
Gadro testified at trial.
He did.
And is he the person who interviewed all the other witnesses too? Or are there different police officers interviewing the different, like the person on the cash register, Whalen or?
That was also Sergeant Gadro and the late Lieutenant Gibbons from the state police. So he was the lead investigator. He interviewed the majority of the witnesses. I can't say he interviewed every one of them. But even with the audio experts, again, and I think this point was raised earlier, they're finding anomalies and wave shifts and who knows what throughout all of the recordings. So that seems to dilute or the claim that the police were maliciously cutting and pasting and snipping Mr. Bateman's interview to make it look more nefarious than it was.
Do you have a sense of how Whalen's missing interview one suddenly became found?
So there was a finding that it wasn't produced because apparently.
Oh, yes. So Mark Whalen, we were talking about him before, he's a witness. And then apparently they lost his first interview and then it suddenly revealed itself. Mr. Gagne, do you know how that exactly happened? Hang on. Let's hear that question again.
Sense of how Whalen's missing interview one suddenly became found?
So there was a finding that it wasn't produced because apparently the wrong interview was duplicated or recorded over segment one, and it was in post motion for new trial discovery that the Commonwealth reopened up its file and went through it and provided everything to the defense, and that's when it was discovered.
Wait a minute. You mean it overwrote itself? You mean it was recorded over? Where have I heard that before? That the video overwrites itself every 30 days, but then suddenly it just didn't, because all of that video was then discovered in a drawer after the first trial in the Sally Port regarding Karen Reed's first persecution. It was overwritten, but then it wasn't. And then you found it, 17 years later, 18 years later? Are you kidding me? Let's hear that again.
Do you have a sense of how Whalen's missing interview one suddenly became found?
So there was a finding that it wasn't produced because apparently the wrong interview was duplicated or recorded over segment one, and it was in post motion for new trial discovery that the Commonwealth reopened up its file and went through it and provided everything to the defense, and that's when it was discovered. So there was a finding that there was a discovery violation, but nothing intentional. And I would also note that.
How do we know? How do we know that it wasn't intentional? Dude, how do we know it wasn't intentional? Should we just believe you that it wasn't intentional? Okay, you can't use this as a shield and a sword. You can't say, oh, well, we just found it and it wasn't intentional, and then say to the defendant, you can't prove that it was intentional, that the audio was edited. You can't use it and say it's okay when I do it because it wasn't intentional. But, we don't want the jury to hear about them doing it. You can't use it as a shield and a sword. And this is the DA's office not turning something over. And we've seen this before too. Wow. Hear that again.
Discovery that the Commonwealth reopened up its file and went.
After the, wait,
So there was a finding that it wasn't produced because apparently the wrong interview was duplicated or recorded over segment one, and it was in post motion for new trial discovery that the Commonwealth reopened up its file and went through it and provided everything to the defense, and that's when it was discovered.
then we
So there was
provided
a
them with
finding that there
everything.
was a discovery
After it's
violation, but
convicted.
nothing intentional. And I would also note that with that witness, Mr. Whalen, there were 3 segments of his recording. The defense had segments 2 and 3, as well as a written statement from Mr. Whalen, essentially saying what he had said in the first segment, which wasn't turned over until most recently.
And his DNA is found under her fingernails, is that? So they did do a DNA of her body, and he's the only person who shows up on the DNA.
There was
is that
unknown
right?
DNA.
Yes, I'm not aware of any other third-party culprit DNA on her body other than the defendant's.
What about the representation that there was DNA found on her ear?
Oh yeah, saliva.
That is
Saliva was found on her ear. What about that? What, can we talk about that?
a portion of the record that I have not personally seen myself.
Oh.
If there was saliva on her ear, I'm not aware of any DNA testing having been done on it or any other profile having come from it. I think what if I can just answer, I see I'm a little bit over time. There's always a selection of which DNA testing may be most viable in a case, and obviously here the ligature and under her nails. I think once Mr. Bateman's DNA was on those 2 points and he admitted being there and interacting with the victim that day, there comes a point where you say, you can't test everything.
I'm sorry. I'm so sorry. She was strangled with a belt. I'm assuming around her neck, right? And you don't test the saliva on her ear? Because if a guy was behind her strangling her with her belt and maybe was drooling on her, that wouldn't be important. It wouldn't be important to test the saliva on her ear. Are you fucking kidding me, Gagne? Sorry, guys. There comes a point where, you just can't test everything. You just can't test everything. Based on that alone, he should get a new trial. Fight me on it. Fight me on it. The drool is the key. The defendant, Dennis Bateman, was friends with Brandy. They were friends. He admits he went to the gas station. He went to the gas station because his car was blowing up or smoking or whatever, his black van. And while he was inside, he was talking to Brandy. Maybe he hugged her, said hello. Maybe he touched her belt. Maybe there's touch DNA on her belt from him. They're friends. She goes in his purse. He goes in her purse because he says, I need some change for whatever. And she says, go in my purse and get it. And he does. And then he leaves. And then a couple of witnesses see a black man with hair. And he says he was on the other side of town when they say she was killed. And he was a little whacked out because he bought some crack. Let's hear that again, because, there comes a time where we just can't test everything. We found his DNA. We don't care. We knew they were friends. It doesn't matter. Come on, stop. Or maybe, yeah, right. Maybe he was telling her not to scream. Maybe he was whispering in her ear sweet nothings while he's choking her with a belt. And maybe you got the wrong guy in jail for 18 years, but no big whoop. There comes a time where, we can't afford to pay Bodie Labs to test the DNA of the saliva on the dead girl's ear. And yes, he was charged with 2 counts of murder and convicted of 2 counts of murder because she was 7 months pregnant. I need to take a breath. Okay. Let's hear that again.
So they did do a DNA of her body, and he's the only person who shows up on the DNA. Is that right?
Yes, I'm not aware of any other third-party culprit DNA on her body other than the defendant's.
What about the representation that there was DNA found on her ear?
He literally just lied to them. I'm not aware of any other DNA. And it takes one of the justices to point, what about the saliva on her ear? And he says, oh, I didn't read the papers? I didn't read the papers? He just lied to the court. But he can say, oh, but I didn't read the papers, so that's why I said I wasn't aware of any. Come on, man.
That is a portion of the record that I have not personally seen myself. If there was saliva on her ear, I'm not aware of any DNA testing having been done on it or any other profile having come from it. I think if I can just answer, I see I'm a little bit over time. There's always a selection of which DNA testing may be most viable in a case, and obviously here the ligature and under her nails. I think once Mr. Bateman's DNA was on those 2 points and he admitted being there and interacting with the victim that day, there comes a point where you say you can't test everything. Unless the court has any further questions, I would rest in the Commonwealth's brief. Thank you very much.
Because he's embarrassed. Because he's embarrassed. I didn't read that part of the record. Let me stop talking. I didn't read that part of the record. Sorry. You have one job, Gagne, one job. Read the fucking papers when you go in there to argue, and don't lie to the appellate court. Don't make a judge ask you about the untested saliva. Well, he admitted he was there. You know, so there comes a time where we just can't test everything. They were friends. She worked at a gas station. A lot of people were there that day. Guess what? A lot of people were there that day. It wasn't like she was murdered in her home. She was murdered at her place of work at a gas station where she worked, the Deerfield Sunoco station. A lot of people were there that day. He admitted to being there. Wow, you know, it reminds me a lot of Richard Allen, who admitted to being on the bridge that day. So they just, you know, he must have done it because he admitted to being there. Is that really what we're going with? One job, Gagne, one job. Be familiar with the papers before you go in to argue. I'm revolted. I'm revolted. I'm outraged. This whole thing is disgusting. And I didn't watch that before. I watched it with you for the first time. So that was a real-time reaction. And I apologize if I blew out your eardrums with my foul language, because you know that I do not like to curse on this show. But sometimes it slips out and it's sickening. Let's go to the chat. Hi, Nina. She says, LOL, I was blocked for weeks and I didn't realize it. And I was commenting to the black hole the whole time until you rescued me from Block Island. YouTube has been doing that to people, and it's not even like a you problem. It's a me problem and a YouTube problem. So all you got to do is send me an email with your channel link if it happens to you. And then when you're in the chat, just don't be a jerk. Thanks, Nina, for tuning in from across the pond. Robin says, thank you for unlocking me and all. You see, it happened to Robin too. It wasn't just you. Thanks, Robin, for your super chat. Amber says, I'm behind, but it's not just women. My male ancestor was put in jail for being a witch. Yes, there are some men too. I was going through all the papers, all of the old papers with the pen and ink, the quill pen in the inkwell. My male ancestor was put in jail for being a witch, escaped during a mass prison break, and was later exonerated. That's wild. That's wild. Thanks for your super chat. And Gus McComa says, Judge Wallahogian is Maura Healy's ex-partner, FYI. Thank you, Gus McComa. Grace Base pointing out that if it's the same file unedited, then the hash values would match. Thank you, Grace Base. Oh, Nicole, don't send me any Instagram messages. I don't get them. They don't come through. They go into 14 different files. So you can send it to the email, which is in the show notes below, fanbase@mlittlelaw.com. A mock-up of the hat. Okay. Is it a PNG? It has to be a PNG. It has to be certain things for them to be able to print it. And that's awesome. Thank you, Nicole, for doing that. Is that the DMB one? And we're going to do it AML. That sounds amazing. Fanbase@mlittlelaw.com. Thank you so much, Nicole. You guys are awesome and very generous. And Libra in Seattle. It says you've been here for 6 months, but she's been here for 2 years, but a member for 6 months. Well, thank you very much. Thank you very much for wanting to be here. Thank you very much. And Tracy pointing out that they even turned the comments off on that HJC stream. Wow. Are we shocked and surprised? Not really. And then Barbara wants to know, Is this the reason the bone on the saw hasn't been tested in the Walsh case? Maybe. Not important. It's not important. I mean, he admitted to living in the house. He admitted to having dinner with her on New Year's Eve. Why should we test it? Well, Lil Mama says, I want to see more appeal hearings. This is very informative and helpful to understand how difficult it is to win an appeal. Just, wow, well, you're in luck. You're in luck, Lil Mama, because we're going to go to New Hampshire next. We're going to New Hampshire, and we're going to watch the appellate arguments that just happened this morning for Adam Montgomery. Adam Montgomery wants a new trial. Adam Montgomery is a monster, and I think, in my opinion, he should never see the light of day. See, here's the thing about me. I don't pick a side. I mean, I don't sit on a fence. I don't sit on a fence because the only thing you can get from sitting on a fence is splinters, and I don't want splinters. Sometimes I side with the prosecution. Sometimes I side with the defense. Depending on, I'm a constitutionalist. I'm a realist. I'm logical. I like to read the court documents and formulate my opinion accordingly. Listen to arguments, watch testimony, evaluate evidence. Adam Montgomery should rot in prison for the rest of his natural life. And for those of you who don't know who Adam Montgomery is, and the reason I did not cover this trial live, I covered this case a lot with Duty Ron before I had my own channel. For those of you, we have a lot of crossover viewers. Duty Ron is amazing. I love Duty Ron with all of my heart. Duty Ron is a 9/11 first responder. He's a retired NYPD, and his partner is Ed Wallace, and they have a channel called Duty Ron. Ed Wallace is a forensics genius. He teaches forensics. He's also in law enforcement. He's amazing. Before I started my own YouTube channel, I co-hosted with Duty Ron a lot because Ed Wallace was off on assignment for a number of months. And we spoke about poor baby Harmony Montgomery for a lot of shows. And it was really hard for me. Like I have 5 kids of my own. Like these horrible stories about children really affect me in a really negative way. And so when this trial happened for Adam Montgomery, I did not cover it live. I just couldn't because the details of it, and I'm not going to even talk about the details of it, but the horrifying details of the Harmony Montgomery case will break your soul and your spirit. And if you don't know about the gory details, I suggest you don't even look them up. Suffice to say that last year, Adam Montgomery was convicted in New Hampshire for the murder of beautiful little 5-year-old Harmony Montgomery, his daughter. He was sentenced to 56 years to life in prison in New Hampshire. I don't even think he showed up to the trial one day. Like he could not be bothered. I think maybe he showed up to trial once and then he just was like, yeah, no, I'm not coming. He just never showed up. And apparently in New Hampshire, you can't force a defendant to come to trial. And so he didn't come to trial. And the details of what happened to little Harmony, you cannot unhear. And so I'm not going to tell them to you. If you're curious, go out there, but I'm going to warn you, you can't unhear them. At the time of Harmony's death, Adam Montgomery was married to a woman named Kayla Montgomery. They were both addicts, and there's no shade. But Harmony's mother, Crystal Story, I think her name is Crystal Story, lost custody of Harmony because of her addictions in Massachusetts. Lost custody of Harmony. A Massachusetts judge gave custody to the biological father, Adam Montgomery, who lived in New Hampshire. And I seem to remember that this happened sometime around 2020. So you know what was happening then. Don't write it in the chat. Even though Harmony's biological brother had been adopted by a lovely gay couple who wanted to also adopt Harmony, something happened where Crystal had to be in court at 2 different courts, 2 places at the same time. And somehow this lovely couple, these men who wanted to adopt Harmony, could not adopt Harmony, even though they wanted to keep the children together. And it didn't happen that way. Harmony went to Adam Montgomery, who was a felon and an addict, who lived in New Hampshire, and zero follow-up was done. By the time that Crystal Story, I forget her name, even reported Harmony Montgomery as missing, she hadn't been in touch with her for a very, very, very long time. Yeah, Judge Carol Erskine is very, very involved in this, and she's been analyzing it, and she's amazing. She wrote a whole blog on it. Yes, that's what it was. Sori was supposed to be, thank you, Free Kelsey, at 2025. Sori was supposed to be at 2 courts in 2 different states, Massachusetts and New Hampshire, for hearings that were scheduled at the same time regarding the children, right? He was a felon. He was an addict. At the time of her death, they were living in the car. They had just been to like the methadone clinic to get their dose for the day, and they drove through Burger King. And the details are just so horrific that I don't even want to tell them to you. So Adam Montgomery was tried and convicted in New Hampshire. He didn't even show up to court. Here's why he thinks he deserves a new trial. Number one, he says that the trial, because he was tried for both the murder charges and the assault charges against Harmony in the same trial, that was prejudicial. That shouldn't have happened. Those two charges should not have been joined for trial because they didn't happen at the same time. It's not a result of the same event. That's one reason why he thinks a new trial. He should get a new trial. The second reason is that the court should not have allowed testimony from Kayla Montgomery, because Kayla Montgomery was serving prison time in New Hampshire for lying to the grand jury. She perjured herself in front of the grand jury. She may be one of the only people ever convicted of perjury. And she was serving, I think, 18 months in prison. And he says that she's not credible. And so the court should not have allowed the testimony from Kayla Montgomery. And the third thing that he says, the reason why he deserves a new trial is because the body cam video of when he was found in his car on, I think, New Year's Eve with his new girlfriend living in his car, the body cam footage of that, he says, should not have been shown to the jury, that it was very prejudicial, that it was more prejudicial than probative. And so for those 3 reasons, he thinks that he deserves a new trial. Okay, so let's watch the oral arguments in front of the New Hampshire Supreme Court from this morning. I just need to find them. So just hold on one second, because you know what happens when I have too many tabs open on my computer, and then it gets drafty in here. And things glitch a little bit. All right, let's see. Court TV aired it this morning. And each side was only allotted 15 minutes, so I don't think it's going to be very long. I think it's only about a half an hour. Maybe. Okay, hang on. And let's just look at the Supreme Court of New Hampshire. First of all, excellent paint color choice on the walls. It's beautiful. So thanks, little mama, for wanting to see more appellate arguments. I find them to be very interesting also. And so we're going to watch the appellate arguments from this morning. That's what the whole stream was supposed to be until the Kelsey Fitzsimmons order broke this morning. And we got a little bit sidetracked in the morning, but we had to cover that right away because it was breaking.
Please rise. The Honorable Justices of the New Hampshire.
I may need to boost the audio a little bit, but just give it a second because this first guy who's speaking is not in front of a mic. Let me see if I can put on the, look at the beautiful paint color. This is a beautiful room.
Please be seated. The New Hampshire Supreme Court is now in session.
This is case 2024-0304, State of New Hampshire versus Adam Montgomery.
Good morning. For the record, Justice Hans Marconi is disqualified in this case. And Attorney Phelan, I understand you reserved 2 minutes for rebuttal.
Yes, I have.
Please proceed.
Oh, you know, Shark Boy, I thought you were a troll and I was giving you a chance. This is how you know. Joined YouTube 3 months ago. Asked a lot of other questions trying to get a reaction out of me, like, how bad the lawyer was and arguing the appeal for Dennis Bateman, what's on the missing audio, and then comes out with this nugget. Question, why do you keep talking about Karen Reed when she was already acquitted? Oh, Shark Boy. You know what's really lovely this time of year? Block Island. It is so lovely. I think you're really going to like it there. Anybody have boarding pass emojis? Bye-bye. You got your 5 minutes. Not even 5 minutes. You got your 30 seconds of fame. Shark Boy is Steven Zabrowski. I don't know who that is. Should I know who that is? Bye, Shark Boy. Only joined YouTube 3 months ago. Ridiculous. All right. He's got to interrupt the whole class and, get a little attention for himself. All right. Here we go.
Good morning. For the record, Justice Hans Marconi is disqualified in this case. And Attorney Phelan, I understand you reserved 2 minutes for rebuttal.
Yes, I have.
Please proceed.
Good morning. May it please the court, my name is Pamela Phelan, and I am here on behalf of Mr. Montgomery. Today, I'd like to talk about 3 issues. First, the court erred in joining the July 2019 assault charge with the homicide-related charges. Second, the court erred in admitting as intrinsic evidence of other assaults in the weeks prior to the homicide and of blocking communication between HM and her mother. And lastly, these errors were not harmless beyond reasonable doubt. I did raise another issue in my brief, and I'm happy to answer any questions about those, but I'm going to focus on these. The principal...
Okay, is the volume okay? Notice they're not going to say Harmony Montgomery's name. That's who they're referring to when they say HM. The judge was disqualified for a reason that I will tell you about a little bit later. Somebody asked that. Okay, here we go.
Concern with these issues is that a defendant be tried on the merits of the charged act and not on propensity and character inferences that may be drawn from evidence of other acts and wrongs. On the first issue, the cases simply should not have been joined for trial. They were not logically and factually connected in a manner that does not solely rely or demonstrate the accused has a propensity to engage in criminal conduct.
What make a difference?
Go ahead.
Does it make a difference that the defendant had joined and the state's assented to motion for joinder in the first instance?
No, I don't. And the reason I don't is because my recollection is that the parties agreed to joinder early on in the pendency of the cases, and then as they neared trial, the defense moved to sever them for trial. The state did not contest that the defendant had a right to do that and to have the court look again
So if
at
it,
whether it should be
I guess
severed.
my question is, if it was in the best interest of justice at the moment the defendant agreed to join the cases, what changed?
What changed is I think through the as defense counsel said, through the development of the case in preparation for trial and additional information that was coming out about how the state was intending to present its case. And defense specifically referenced new discovery or new information in Zwicker letters that were being produced to the defense.
Are the Zwicker letters part of the record? Because I looked at the motion to sever, it references the Zwicker letters, but I didn't see them in the appendix.
No, they are not. But defense counsel talked about what was in them, and state's counsel when they argued the issue about whether the charges should be severed for trial. And at that point, the defense was primarily concerned not only from what was coming from the Zwicker letter, but in how the defense was perceiving the state's theory of the case going into trial, that this was going to be a trial about demonstrating a pattern of abuse. And that was going to be the prejudice that was going to result to Mr. Montgomery by having the charges continue to be joined for trial. And that was the principal concern that the defense had and articulated to the trial court below.
Did the new information include any information provided by Kayla Montgomery?
I believe one of the Zwicker letters did include information from her. I can't remember exactly which witnesses were involved in those.
What's the significance of the two different states of mind between the July assault and the murder, the reckless murder?
I'm not sure what.
In terms of this analysis, does the state of mind of the two different criminal acts have any bearing on our analysis for joinder?
I don't think so. I haven't thought about it in that way. I've thought about it in going through the Brown factor analysis that this court has articulated, as well as the tests that the court uses to determine interests of justice. I think the concern when you join those two cases together in this case is that you have evidence of the July assault, which, as you note, did have a different mental state, a knowing mental state. But that evidence rested on several different witnesses who did not have credibility problems, whereas the homicide case rested on the testimony of Kayla Montgomery, and she had significant credibility problems. So to the extent that evidence came in through the joinder of these two cases for trial about and through witnesses, third-party witnesses without credibility problems, the July assault was much stronger. And to the extent that the jury likely had significant doubts about what Kayla's version of events were for December 7, which is when the homicide is alleged to have happened, the jury could very likely have relied on the strength of that assault charge case in resolving doubts against Mr. Montgomery on the homicide charge.
Counsel?
Yes.
So is it fair to say that the Zwicker letter changed the defense's calculus with respect to the best interest of justice prong of the analysis, but that when there was a stipulation to join the two cases, that the defense had concluded that they were sufficiently related, that they ought to be joined? In other words, you're challenging relatedness, and my question is, doesn't the Zwicker letter only go to the issue of best interest of justice?
I don't think so. My recollection of the hearing on the motion to join or the motion to sever, which was also the final pretrial conference, I don't know how in-depth, I can't remember how in-depth counsel for the state and the defense went in to the original calculation or the original analysis of joinder. There wasn't a prior hearing on joinder, and so I don't know if we can be very clear or have a clear understanding that the defense at some point thought there was a relatedness, or the defense might have thought, just like the state, there may be some efficiencies in trying them together. But as the cases got towards the trial date, it was clear to the defense, as they made clear to the trial court, that they were concerned about the effect of a potential pattern of abuse being used primarily to affect the jury's weighing of evidence on the homicide charges.
At the time that the state initially agreed to joinder, was there a decision made or on the motion to eliminate to prohibit the intrinsic evidence that came in?
I don't know if, I think over a year earlier is when the cases had gotten joined and started towards trial. I don't know at that point whether there was any written agreement or stipulation about evidence, or whether it was tied to the admissibility of other evidence in the case. And the other issue that I want to address this morning has to do with that ruling about some of the evidence that the court determined was intrinsic. I don't think that was there was any agreement that tied the intrinsic evidence issue to the joinder issue.
So the admission of but you would agree, I assume, that the admission of this intrinsic evidence, the assaults and abuse and neglect that occurred in the weeks before, the murder, that affected the admission of this assault in July, that it made it compounded.
Correct. Yes. I mean, I think both issues are intertwined in the prejudice that resulted to Mr. Montgomery. And it's, even if we're looking at the joinder issue, I think to your point, the prejudice is not just to his trial on the homicide charge, it's also potentially to the trial on the assault charge, because as you point out, the intrinsic evidence came in as intrinsic to the homicide charges. And certainly it was there in the case for the jury to use in assessing both charges, the assault charge and the homicide charge.
So I want to give you an opportunity to address harmless error, but why don't you proceed with your second argument?
Yes. So with respect to the intrinsic evidence,
Do you notice the difference in demeanor between the appellate judges in Massachusetts that we watched before this and the appellate judges in New Hampshire? I mean, it just, at first blush, the Supreme Court judges in New Hampshire seem to be much more respectful to the defense attorney. I don't know, just putting it out there.
issue. There were two pieces of evidence that I focused on in my brief, and I believe it was error. They were not intrinsic to the homicide-related charges, which is what the trial court found. It was the assaults in the weeks leading up to the homicide, and then the bar of communication. With respect to the assaults, the state, even on appeal, says that those assaults, prior assaults, were necessary and essential to proving reckless intent on the homicide. That simply isn't the case. If you look at the state's evidence on the homicide charge, it's the evidence demonstrated, and the state argued that it demonstrated, that Mr. Montgomery acted recklessly by repeatedly punching HM until she was unconscious. You don't need additional evidence of prior assaults for which there is no allegation was connected to cause of death to prove that reckless mental state.
Doesn't it show the extreme indifference?
I think the charge itself shows extreme indifference. The evidence on the charged act, if you believe Kayla's testimony, that in and of itself is more than sufficient to establish recklessness. And I will also point out that this was not a mental state defense on the homicide charge. This was a defense that Mr. Montgomery was not the one who caused the death. It was Kayla Montgomery. And so intent.
Keep in mind also the difference between these two cases. The details of this case involving Harmony Montgomery are so gruesome that I won't even repeat them to you. So gruesome. Her body's never been found, right? I just was thinking about that cooler, and the judges are still being very respectful to the defense attorney, right? This man is a monster of epic proportions. I think this may have been the most gruesome case that I've ever known about involving a child. And they're still being respectful to her.
On the homicide charge was not a matter in serious dispute. And I would also like to point out is if you're talking about other act evidence being relevant for intent, that's a 404B evidence that's subject to a 404B analysis. That's not an explanation for it being intrinsic to the charge.
Wasn't as the trial court noted, wasn't the jury entitled to some context about events leading up to December 7th?
I don't know why. I mean, context has to be tied to the actual the charged act. I don't know, and I guess this is a question for the state, but what about their evidence and proof on the homicide it has a hole or a gap in it that is impossible for a jury to understand and reasonably assess without having these prior assaults.
To Justice Donovan's point, your yellow light is on, and if you want to get to harmless error.
I do want to get to harmless error. I think that, as I mentioned before, the homicide-related charges rested exclusively on Kayla Montgomery's version of what happened on December 7th. She had significant credibility problems. She gave multiple inconsistent statements to the police before she eventually gave a statement that led to the basis of her trial testimony. She only gave that story after she had been arrested, jailed, and was facing additional jail time. She had theft and other kinds of convictions on her record that raised substantial questions about her credibility. She, according to the state, lied to the grand jury about what happened, and by the time she got to testify in this case, she was serving a prison sentence on perjury. She had significant credibility problems. The admission of all of this other evidence, either through the joinder of the July assault and the prior act evidence leading up to the assault, the homicide, all of that rested on other evidence. And it gave the jury a reason to, even if they likely had substantial doubt about what Kayla said happened on December 7, they could fill in that doubt by relying on the improper admission of the July assault evidence, as well as the prior evidence leading up to the homicide.
Thank you, Attorney Phelan. You've reserved 2 minutes. Attorney Gagne?
Good morning, Your Honors. May it please the Court, Sam Gagne for the State of New Hampshire. Your Honors, the trial court committed no error when it denied the defendant's motion to sever, when it admitted intrinsic evidence, or when it admitted the body cam video. But even if it were to be assumed that the trial court did commit an error, any such error was harmless beyond a reasonable doubt, given the nature of the errors alleged in this appeal and the overwhelming strength of the state's case, which consisted of eyewitness testimony, numerous witnesses who corroborated that eyewitness testimony, and a mountain of physical evidence, the summit of which held only one conclusion, and the jury reached it.
Do you agree with the defense that the murder conviction rested predominantly on Kayla Montgomery's testimony?
Not necessarily, Your Honor. Certainly her testimony played a large part. She was the eyewitness to what happened on December 7th, 2019. There was no specific evidence to corroborate exactly what happened in that car as far as eyewitness testimony. But to the extent that could not be corroborated and Kayla has credibility issues, so much of what Kayla testified to was corroborated by other testimony and physical evidence that she might not even have been aware of, that it would have become very easy for the jury to later credit her testimony about what happened in that car.
So if we excise the July assault, what evidence corroborates Kayla Montgomery's testimony?
Sure, Your Honor. So beginning with the blood in the ceiling of the Fitz shelter, Kayla testified that the defendant hid Harmony's body in a diaper bag and placed her in the ceiling of the shelter at Families in Transition. When the police went...
I should have trigger warned you, but I trigger warned you before, but I didn't know this was coming because I'm just watching this with you right now for the first time. So if these are details that you did not know and cannot stomach, please turn it off. I will totally understand. Come back later. Because after this, we're going to watch EmilySeee, and she's going to make us laugh, and we're going to have a really great palate cleanser. So there's not that much more left of this, maybe 20 minutes. I totally understand if you have to go. But for those of you who want to know the details, here's what happened. FIT, the Fitz shelter, is Families in Transition. It is an organization, or I guess a state-run organization that helps homeless families and gives them a place to live. So when he says Fitz shelter, that's what he means, Families in Transition.
Kayla Montgomery's testimony.
Sure, Your Honor. So beginning with the blood in the ceiling of the Fitz shelter. Kayla testified that the defendant hid Harmony's body in a diaper bag and placed her in the ceiling of the shelter at Families in Transition. When the police went to investigate and cut out that part of the ceiling, it was visibly stained with bodily fluids. The DNA tested positive for Harmony Montgomery's DNA, a profile of which was built using her toothbrush. The defendant's fingerprints and palm prints were all over the vent of that ceiling. The only other fingerprints that were found were of the man who installed the ceiling.
But that only shows corroboration of the post-homicide actions of the defendant.
Sure, Your Honor. My ultimate point here is that all of these pieces of corroborating evidence of Kayla saying he hid her in the ceiling, he put her in the freezer at Portland Pie Company, he used a U-Haul to drive her and dispose of her body, he used lime to break her body down. If all of those things could be corroborated by physical evidence to show that Kayla wasn't lying about those things, it becomes a lot easier to credit her testimony when she says, the look of an evil man in that car is why I didn't do more to stop him from raining blows on her face. That becomes a lot easier to buy once the rest of her testimony is credited, and very, very much of her testimony was. Again, through physical evidence and then through the testimony of other witnesses, such as Travis Beach, a friend of the defendant's. He testifies that, yeah, I helped procure the U-Haul truck. I couldn't get it myself, but my friend Brendan Harris could. Brendan Harris said the same thing, and then the U-Haul records show that Brendan Harris indeed did procure a U-Haul truck. Massachusetts tolls show that the defendant went over the Tobin Bridge in that U-Haul truck on March 4th, 2020 at 4:45 a.m., and he crossed back over going northbound at 5:25 a.m. The records showed that there was about 130 miles put on that U-Haul truck, and by the state's calculation, that would have lined up just about with the trip from the U-Haul back to the Econo Lodge down to about where the defendant allegedly disposed of Harmony's body and back up. So there was significant amounts of corroborating evidence. On top of that, outside of the Econo Lodge, Travis Beach says that he's outside with the defendant smoking a cigarette, and the defendant's pacing back and forth repeatedly saying, I effed up, I effed up, I effed up. And Travis asked him, what are you talking about? And he wouldn't clarify. That's the same night that he disposes of Harmony's body. So the evidence just built upon itself over and over and over again, and that's even before we get to consciousness of guilt evidence of the defendant himself. He tells somebody on a jail call that the efforts to find Harmony's body is just a waste of taxpayer money. One could draw an inference from that yeah, I dumped that in a place you're not going to find it. Additionally, before he was arrested, but well after the murders, the defendant confides in somebody who calls himself a close friend of his that he hated Harmony to his very core because Harmony reminded him of Crystal. That makes it really easy to start believing that this person took on an evil demeanor and rained punches on this 5-year-old girl's head until she was dead.
One of the predicates for the Superior Court's decision to allow the pre-December 7th abuse and neglect of Harmony in was that the court would give a robust instruction to the jury so that it did not take into account those prior acts in order to establish a propensity. Did the Superior Court give that robust instruction? I looked at the instruction and it did not seem to fit that description. Do you recall?
So what I recall, Your Honor, is in closing, in the final instructions to the jury, the court did instruct the jury, as is routine, that each indictment must be considered separately, and it was directly instructed to the jury that a finding on one indictment should not influence a finding on the other.
But there was no instruction on this particular evidence, the intrinsic evidence or the July 2019 assault.
I do not recall that, Your Honor.
I didn't see it.
I do not recall that from the record. Speaking of, just to pick up on that, there was some discussion of the intrinsic evidence causing the July 2019 assaults to bleed into the murder charge, creating that concern of propensity evidence.
Well, how do we reconcile the fact that the trial court limited the intrinsic evidence of abuse and neglect to a very specific time frame of 2 weeks prior to November 29th, and then the time frame between late November and December 7th, yet allowed in, obviously, by not severing the July assault? How do we reconcile that?
So I think they can be reconciled. First, I would note that they are certainly two different issues. One's a joinder issue and one's an intrinsic evidence issue. And I think the trial court took the exact right approach. The trial court was cognizant because the state moved for months of abuse and neglect evidence. Months takes us from November 29th. If months is plural, that's October, September at least. Then it could start getting into August. The trial court, my decision is somewhat here. These are joint.
That's Core TV that's glitching, not me, right? All right, we'll just work through it.
Abuse into September, August, God forbid July, these cases might start to bleed together. So if the joinder order is to remain a sustainable exercise of discretion, the court has
and that with respect to the 2 weeks prior to December 7th is material to the crime charged?
Yes, Your Honor. First, I note that Attorney Phelan mentioned she did not understand why any of that was important. I think the easiest way to respond to that before getting into more substantive reasons is, as this court says time and time again in intrinsic evidence cases, events don't happen in a vacuum. This murder did not happen in a vacuum. The whole story is not told by simply recounting the events of December 7th, 2019. If that's all that is told, all you get is that in a vacuum. I'm not saying this would have been the defense or it could have.
All right. Glitchy. Did it freeze up Barbara for the rest of it? Barbara watched it live.
The way that a father is supposed to treat a 5-year-old her life, he did not treat her the way that a father is supposed to treat a 5-year-old daughter. He treated her like an object of inconvenience, and that evidence showed that. Beyond that, as I kind of just wrapped up, it completed the story, and it was necessary to complete the story. The state has a right to present its case. The jury has a right to hear evidence that does complete the story, because again, events don't happen in a vacuum.
If that's the case, then why was the video from 2 years later, why was that admissible? What's the relevance of the Manchester Police's encounter with Mr. Montgomery 2 years after the murder?
So that does continue to tell the entire story of the case, Your Honor, because that is it's really the beginning of the story from the law enforcement perspective. That's how the investigation starts. That's the first interaction that law enforcement has with the defendant. It is relevant that when this is reported to the police, what they know is that Harmony is missing. And they say, okay, let's find the defendant because he has custody of Harmony. And it's relevant for the jury to know when the police located the defendant looking for Harmony, where was he? Who was he with? Harmony wasn't there. That's certainly relevant. There is relevance to that. Now, I'm not going to say that the probative value is through the roof on
He was living in his car with his new girlfriend.
Body cam video, but it was relevant. And the reason it was properly admitted is because the risk of unfair prejudice did not substantially outweigh even small probative value.
And his new girlfriend, correct me if I'm wrong, chat, but his new girlfriend didn't know anything about Harmony. Didn't even know he had kids.
Intended that it was more than minimal probative value, but even if that's what it was, the risk of unfair prejudice did not substantially outweigh that. The prejudice that the defendant has set forth both in the trial court and in this court is really a tenuous risk of prejudice that is based on mere conjecture and speculation. This video had no audio. The defendant could not be heard. At defendant's brief, page 41, the defendant says the video shows the defendant seemingly answering questions. In that circumstance, and the defendant argues that the risk of prejudice is that the jury is going to infer somehow that he was not cooperative with police, or that his right to remain silent was implicated. But the fact that there's no audio, he's shown answering questions, and that defendants carry into trial a presumption of innocence, there was no rational basis to speculate that the jury would take that video and just imply from it that the defendant was being not cooperative with police in that moment while they were just looking for harmony.
Was there any objection to the testimony about that encounter, separate and apart from the video?
I don't want to say definitively, Your Honor, but I don't believe that there was as I stand here, but my recollection of that is not good enough to answer definitively. Looking quickly to the severance charges, the severance issue, the state notes that, as Justice McDonald pointed out, that the defendant initially moved to join these charges and assented to a motion, and later had a change of heart, which he was entitled to do. The state notes that the case summary, which I don't know is part of the record, but the state could supplement if the court wished for it, seems to show an appearance of another defense counsel between the joinder and the motion to sever. And all of this is really to say that it seems odd that defense counsel at one point in time could have reached this conclusion reasonably and then changed their mind and perhaps reached a different reasonable conclusion, but then argues that the court clearly was unreasonable and untenable in reaching the same conclusion that they had reached earlier. Now, Justice McDonald also asked what changed. As the state argued in the trial court, as far as substantive information, nothing changed. What changed was that some of the stuff is now coming from Kayla. That, it's lost on me, as Justice Gould pointed out, how that could impact the relatedness factors. Perhaps it speaks somewhat to the interest of justice issues, but it does not speak to the relatedness factors. Secondly, the July 2019 assault evidence, it's a little bit difficult to game this out because it's sort of hypothetical, but if these charges were severed, it's certainly possible, if not likely, that the July 2019 evidence could come into the murder trial under Rule 404B. Depending on what the defense and what the state of the facts were, the theories could have been modus operandi, lack of mistake, habit of the defendant in the way he disciplined the child, harmony, common plan or scheme. There's a number of theories that may have come in under anyway. The trial court may have been cognizant of that and thought that was another reason not to try the case twice. But even getting to the Brown factors themselves, the trial court's order is manifestly reasonable. If you go through the 5 factors, the state conceded and the court found there was no temporal and spatial relationship, so that pebble goes on the defendant's scale. The commonality of the victim and the defendant can't be disputed here. That clearly goes on the state's scale. The similarity in the mode of operation. In July 2019, the defendant gets angry at Harmony and he punches her in the face. On December 7, 2019, he gets angry at Harmony and punches her again in the head. I see my red light is on, Your Honor, and so we would ask the courts to affirm the trial court's orders and rest on our papers. Thank you.
Thank you very much, Attorney Gagne. Attorney Feeling, you have 2 minutes.
Thank you. With time, I will cover 3 points. Regarding the corroboration.
I gotta take a break. Thank you, Lady Zelda, for your generous Venmo. And your lovely compliment. She says, thanks for bringing all things to light. Thank you, Lady Zelda Kelly. I appreciate you so much. All right, let's let her do her 3 points. It's only a couple of more minutes, and then we will move on to some other things. Wasn't Kayla given immunity for testifying against him? And didn't Crystal Sorey get some money from a lawsuit against New Hampshire, DCYF? Tell me if you know. Don't guess, but if you know for a fact how much money Crystal Sorey got from her lawsuit, if it's been publicized, I don't even know if it's public. Let me know.
Evidence, Justice Gould, the state answered your question and talked about substantial, in their view, substantial corroborating evidence. As you pointed out, Justice Gould, the corroborating evidence is all about post-homicide conduct. And Mr. Montgomery at trial did not contest the charges and agreed to the charges of falsifying physical evidence as well as the abuse of corpse information. So the fact that there was corroborating evidence about those events doesn't mean that Kayla's version of what happened on December 7 was any more true. She had substantial reasons herself and credibility problems to not be telling the truth about what happened. Regarding intrinsic evidence, the state used a lot of words in answering some of your questions. The evidence was necessary to complete the story, to give context, to tell the whole story. This court has been very clear, whether it's talking about intrinsic evidence or 404B evidence, that those are usually passwords, or the court has to carefully construe whether those words are passwords for getting in propensity evidence for a propensity purpose. Evidence has to come in for context when it's necessary and essential to proving the charged act. The events leading up to December 7 in those prior weeks were not essential and necessary under the test this court has applied for considering whether it's intrinsic evidence.
Why isn't it relevant to whether the defendant snapped on December 7th?
Well, that wasn't the defense at trial. And until and unless the defense opens the door to that kind of evidence under that theory, it's not admissible. And as we know, as the trial played out, the defense was not that this was a lack of intent. The defense was he didn't do it. Thank you.
Thank you very much, counsel. Case is submitted. Court in recess.
All rise.
Okay, a couple differences that I picked up on between the New Hampshire Supreme Court arguments and the Massachusetts Supreme Court arguments, or SJC. The judges are much more respectful in New Hampshire. Somebody said to me through Venmo, who I will not name. Oh, that's regarding Kelsey Fitzsimmons, so I'll address that in a minute. Also, the prosecutor in the New Hampshire case, Adam Montgomery, seemed to know his case a lot better than Steve Gagne did, because, Steve Gagne admitted he didn't read all the papers, and so he was unfamiliar with the saliva DNA from the victim's ear not being tested. He didn't know about that. This prosecutor is very prepared, and the judges were more respectful. Just two of the things. Yeah, the mother of Harmony Montgomery's wrongful death lawsuit was dismissed. That's a different lawsuit. So Crystal, Sorry, what the hell is her story? Sorry, it is Sorry, S-O-R-E-Y. She filed a lawsuit against the state of New Hampshire, and I think it was settled for $2.25 million. And she's still going after Massachusetts because of all of the, not allowing her to report Harmony missing, not following up on the placement and such other things as like that. And so, there's another troll. Here we go. Another troll. Mikey, I'm not blocking people that I disagree with. I'm blocking people that are dicks. Okay. So if you're going to come in here and be a dick, that's different. If you have something, Mikey, he says, if you say you stand for the First Amendment and free speech, why do you block people you disagree with? Doesn't that make you a hypocrite? Freedom of speech. I'll explain to you how the Constitution works. That is a right granted to you by the U.S. United States of America. As such, you do not have the right to freedom of speech in my chat. It's a private chat. I can pick who I want to engage with. And so if you're going to be a dick, then I'm going to block you. If you want to disagree with me respectfully, you have every right to do that. So Mikey, RRR, if there is something that you would like to discuss with me, go ahead. I've been called far worse than a hypocrite. And if you're on the cesspool of Twitter, it's probably you that's doing it. Okay? And so there's a difference between being a jerk and disrespectful and degrading and saying nasty things to me, about me, and at me than there is by disagreeing. If you can have a respectful conversation, you're welcome here. If you can't, you don't need to be here. If you're going to just come in here and stir the pot and try and make trouble, like a certain lot of people like to do, you're not welcome here. That's it. I don't have to give you freedom of speech. That's not how that works. Get it? Yeah. There's your 3 minutes that you were looking for. All right, we need a break. We need a breather. Let's watch some EmilySeee. EmilySeee did a mock-up of the Cellebrite videos that Ian Whiffen did, and I think they were amazing. So we need a little break. And so go to Twitter. That's probably where you're most comfortable. You know, people who hide behind fake names to just go out there and say nasty things about people, that's not my jam. So if you can't be nice, and it wasn't you anyway, it was some other jerk.
Cellebrite. Ask.
Hold on. Here's EmilySeee. If you don't follow her on Twitter, on YouTube, go do it. EmilySeee, SEE. Here's her interpretation of Ian Whiffen's videos.
Cellebrite. Ask the experts. Brought to you by our generous sponsors, the Norfolk County District Attorney's Office, in partnership with the McCabe's. Hello, everyone, and welcome to a desperate edition of Ask the Expert. I'm Heather Barnhart, and I'm here with Ian Whiffen, the sexy genius who influenced both Karen Reed trials. The trials were like a super onion. They were like a media circus, and our very own handsome, intelligent Ian Whiffen was the ringmaster of that circus. Ian, I applaud you for your patience and for not flipping out. There were many times I wanted to flip out on your behalf, so I was emotionally in this with you. For those of you that don't know Ian, he's not just the brilliant mind of forensics. He's also our decoding manager here at Cellebrite. So he takes all the things that are stored in that lovely, brilliant brain of his and tries to dump them back into the tools for everyone else that needs Ian's brain to help us. All right, Ian, are you ready for some questions? I am. Go for it. We'll start with an easy one that's probably really straightforward. Why were you brought into this case? I got into this because of a true crime podcaster. But during the trial, I also said the NCDAO and the Mass State Police brought me in. Oh, and also Richard Green and Cellebrite Public Relations. So take your pick. Cellebrite updated physical analyzer based upon your defense of Jen McCabe. Tell us about that research. It didn't look very good for the prosecution that someone had searched for Hoss long, which meant how long, Hoss long to die in the cold at 2:27 a.m. before anybody had found John in the snow. So we updated our software so that you never know what time anybody searched for anything. So what you're really saying, Ian, is that Cellebrite chose to make the tool better for users, and we weren't trying to be part of some giant conspiracy of Karen Reed? Oh, yes. No, we would never update any of our tools for any reason other than a paycheck.
Hold on, because there's a part 2. Hold on. Here it is. Part 2.
Cellebrite. Ask the experts. Brought to you by our generous sponsors, the Norfolk County District Attorney's Office, in partnership with the McCabe's. Hello, everyone, and welcome to part 2 of the desperate edition of Ask the Expert. I'm Heather Barnhart, and I'm here with my hall pass, Ian Whiffen. In part 2, we're going to talk about how spectacular Ian was in court. The judge was even smiling at you, Ian, when you were done testifying. I felt like everyone wanted to give you a round of applause. But there was another side to the story. Ian, you had to turn off your notifications. You were getting distracted by all of the noise. So, Ian, we're going to talk about prepping. Prepping for this case. And just look at him. Clearly, some of that prep was in the gym. I've had many students come up to me and say, hey, we even make our trained investigators watch Ian's testimony. The way Ian can talk you through it and explain even the most technical details so that even my daddy would understand is astounding. I'm going to give you a little applause. Thank you. This is also why in my family, the kids think Ian's a doctor because he's so smart. So he's Dr. Whiffen in our household. So first, tell me about this point. Know your evidence and know it deeply. So you can't just show the data as it appears on the device. Obviously, if we did that, we would be proving that Jen McCabe Googled "Horselong to die in cold" at 2:27 a.m. and then deleted it. So it's important to come up with other explanations to confuse the jury about how it got there and how it might have been deleted. Okay, the next one. Identify the make or break evidence. It's hard to come up with a story about an SMS text message because everybody understands those. So we focus more on the evidence that we can make up additional stories about. How do you prepare for the toughest questions? I let my mind wander. I always keep this card from Michael Morrissey to stay focused on what I was hired to do and to ignore everything else apart from the data. You were so firm. Me, I probably would have poured myself a glass of wine and walked right into that chaos.
I love EmilySeee. Go on over there, give her a like and a sub on the Tubes of You, and like her videos. And you don't want to miss a thing because she's hilarious. Look at my lady. 1, 2, 3, 4. She says I just spit out my drink when she pulled the card out. I saw you put it in the chat that there's some hearing that Hank Brennan is covering today at 2:00. He's defending someone. He's back to his defense practice. Is it on Zoom? I mean, I need more information. I don't know what it's about. I mean, I don't know if I have a Zoom login for that. Is district court may not have a Zoom. I have so many questions, but what time is it now? 1:34. I don't know. I'm running out of gas, you guys. This is a draining morning listening to that Adam Montgomery stuff is just ugh. I don't know. He represents a Cohasset teacher. What is the nature of the case? What's it about? Does anybody know? I don't know. The PTSD that could be had from listening to. So wait, it's not in district court. It's in superior court if it's in courtroom 25. This message that you put up says district court. Is that a superior court? He's defending a child predator who's a teacher? Oh, that tracks. Does it involve dog bites? Oh, Emily. Oh, Emily. And Olivia. Olivia says, thank God for Melanie. I don't know, Olivia. I don't know how much longer I can last. The ridiculousness that is going on over there. I mean, so many of you do not use Twitter, but then, and I don't engage on Twitter either, but then people send me things, people are saying about me on Twitter, which I don't want to know, but then you send it to me. I don't click on it. But I mean, there's some big hubbub over there about me promoting some guy named Ray from Dallas. I don't even know who Ray from Dallas is. I said something on my channel the other day because he was in my chat. And that's a whole thing over there. Like, is it dying down over there? Or is it still like going full throttle about, the whole Karen and like, I don't even know what's going on over there. Oh, it's designed to provoke me, I guess. Yeah. But like, they must be stupid if they think that I engage over there because I don't. And then I was watching Twitter. Then I was watching Turtle Boy's Bus Stop Live this morning, and somebody put in the chat that he couldn't believe what Mike from Young Jerks said about me last night. That Mike from Young Jerks was trashing me on Aiden's show last night. Does anybody know anything about that? Because I didn't watch it. I don't feel like looking for it. So if you know anything about that, let me know. Olivia says, it's ridiculous. People clip you and then put some out of context clip of him as though you're endorsing it. Such just disingenuous actors. Yeah. A lot of agents of chaos out there. A lot of people who are out there trying to cause trouble. Like Little Cupcake says, they all lie because it's the only way they can ever get any attention. Oh, so Mike Crawford did not trash me last night on Turtle Boy show? All right. I don't know. Somebody put it in his Bus Stop Live this morning. Yeah, I don't know. Everybody hates everybody. And then there's people who I don't even know where they came from that are just trying to get other people to hate on other. I don't have time for it. I don't have time for it. Thank you. Mike asked me to come on the Grace Curley show with him one day, and I had another appointment, so I couldn't. But I mean, there's no beef between me and him and that I know of. So if there is, then that's news to me. I don't know. They're all unglued. These people are all unglued and they spread lies on purpose. You're absolutely right. Thank you. This is the person that I will not dox who sent a very nice memo and said, "Hi, Melanie. As I said, I worked for North Andover Police. They are protecting the cop that shot her. He's a favorite. He's a favorite." Here's the guy, in case you don't know, that the judge in Kelsey Fitzsimmons' case is very, very concerned for his safety. Hold on. And that, Kelsey is dangerous. And this is the guy. This is Noonan. So apparently Noonan worked for North Andover PD, and then he went and he worked somewhere else, Lawrence PD, and then he came back to North Andover PD. But let's take a look at Noonan, and you tell me whether you think, whether you think that Noonan is afraid of Kelsey. A couple of issues that I have. Number one, no body cams. Number two, excessive force. I have so many issues, but we don't even have time to get into all of them. All right, so here's Noonan. And this is from a North Andover Police Department post back on Facebook from August 5th of 2004. And it says, "Chief Gray and the North Andover PD would like to welcome back Officer Pat Noonan to our ranks. Officer Noonan has almost 20 years of police experience between North Andover PD and Lawrence PD. Great to have you back, Officer Noonan." And here he is. Here's Noonan. He looks pretty buff to me. He looks pretty jacked. I don't know. I'm just saying. He's in good shape. And then here he is, I don't know, getting pinned, And here he is standing next to a couple of other officers so you can see his size. He's the one with the white beard. And he looks like he's in pretty good shape. And do you think that he's really afraid of Kelsey Fitzsimmons in the same way that Proctor and Buchanan were afraid of Aiden Carney? And as another, so that you can see how big Kelsey is in relation to Justin. This is a public post from Facebook from the North Andover Fire Department from October 2nd of 2024, celebrating Kelsey and Justin's engagement. And look at that, how big Kelsey is compared to Justin. So, when you look at Noonan and then you look at Kelsey and then you say to just Kathleen McCarthy Nyman, N-E-Y-M-A-N, and is pronounced Nyman apparently. She's got to protect the community from Kelsey and protect Noonan, the victim, from Kelsey. Remember, Noonan shot Kelsey, not the other way around. But, it's very important for the judge to protect the community and the victim. And for that reason, she will not allow Kelsey to leave her home arrest to go pee in a cup at a location that is not her home. And therefore, she will stay in jail. She's staying in jail. Her appeal was denied this morning. If you're just joining, we covered that first thing earlier today. And so if you rewind to the very beginning of this stream, you will hear me go over the SJC one judge panel decision denying Kelsey's petition to be let out on bail. So there's that. All right, let me see if there's anything else here I wanted to talk to you about. Oh, here's what it was. Olivia, if you're here. Emily, if you're here. Nurse Kim, if you're here. Apparently the marching orders on Twitter I guess it was starting yesterday, or maybe the day before, was to go out and trash David Yannetti because they are trashing David Yannetti relentless. In fact, Roberta Glass, okay, who has trashed me a lot on her YouTube channel, has put up this video. I'm not going to play the audio to it because there's music and they'll probably strike me. But since it has captions, you can hear it. I mean, you can imagine what it says. And she says, coming soon, hashtag Karen Reed, hashtag innocence fraud. And this is her video. Wait, hold on. Hold on. Do you guys know who Roberta Glass is? She was on Court TV like once or twice. She's from New York. She doesn't show her face on camera. And she's another rage baiter. Karen Reed is guilty. Everyone's a fraud. She talks about me. She talks about everyone else who thinks that John O'Keefe did not get hit by a car. And she's got this whatever it is, YouTube channel show. She's friends with Kate Peter and all of these people. But here's her. This is coming soon. Lying liars who lie. I'm going to put this up. Hold on. Without the audio so that you can just watch, because their marching orders, I think, yesterday were get out there and attack David Yannetti, because David Yannetti went after Julie Carpenter for some dopey thing that she said on Twitter. So here is the preview of the thing that Roberta Glass is going to be putting out soon. Listen. I mean, don't listen, just watch with me. Lying liars who lie. And there's a slow-mo of David Yannetti. It's actually great. This is David Yannetti, attorney at law. He looked great. And then she's got some starring David Yannetti as himself. And then there's, him and Alan Jackson coming out of the courtroom. And then, she's just doing like a whole David Yannetti is a liar video, and it's coming soon to her channel because, she's an authority on how much she hates David Yannetti. And she's not the only one out there. So I think the marching orders from the posse of everyone who hates Karen Reed and like putting on. Oh, I'm gonna actually listen to it in my earbuds, and I'm gonna tell you what the theme song to this is. I'm gonna tell you the words as it plays, the little theme song that they made with AI. Hold on. Lying lawyers who lie. Lying lawyers who lie. Lying lawyers, baby. You're watching. You're watching lying liars who lie. Lying lawyers who lie. Another lying lawyer's been caught in a lie. Another lying lawyer's been caught in a lie. It's second nature. Like putting on a tie. We're putting on a tie. Can you hear it? Oh crap. How can you hear it? Oh, I gotta unshare it. Hold on. Okay, I'll just listen to it in my earbuds. It's what they do. Thanks to him. Thanks to him, cop killers are no longer taboo. No, you can't, because I'm not sharing it anymore. If you guys are behind, maybe that's why you could hear it. But I'm not sharing it anymore. I was just repeating it to you. Nobody messes with Yannetti. Well, if you're on the cesspool of Twitter, get on over there and defend him, because I'm not. I'm not. You guys are behind. I don't even have any audio on right now at all. I don't have any. So there's a lot of people out there trolling David Yannetti, because that's what their talking points were. The talking points for yesterday were troll Melanie Little, troll David Yannetti, and I don't know if there was anybody else that they were trolling yesterday. Disgusting. Disgusting. Get with the program. Take a step back. Nobody puts King David in the corner. Nobody does. All right, thoughts, questions, comments, concerns before we wrap. Amber says, oh, wow, Amber, 23 months we've been together. Thank you. Watched our boy's entire show. Mike said nothing about you. Oh, okay, thank you. Thanks, now I don't have to go watch it. Mike did not trash talk you at all. Thank you, Miss Holmes 66. I don't know, somebody put that in the chat this morning of his bus stop live, and people do that. They do that. So what we got to do is, fight for justice for other people. Because there are a lot of other people who are being wrongfully persecuted, in my opinion, that we need justice. Oh, that's nice. Olive AJ Nichols. Olive AJ Nichols says, I got my man listening to Paris Ray and the Crush. Can we check out Hank? Well, I mean, it's like 12 minutes from now. What else is on the calendar? Hold on. I kind of want to go eat lunch because I've been on for, I don't know how many hours right now. Hang on. Let me see the daily list. See how many cases are on at 2:00. Oh, I'll allow that. You can put Roberta Glass in my chat. That's fine. I'll allow it. Oh yeah, there's a lot of cases on for 2:00. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. But you know what you can do if you want to watch it? All you got to do is call over there to the Norfolk Superior Court. You can get the Zoom information if they turn the Zoom on, and they might not. Let me see which one. Oh, and it's Judge Frenier sitting in there today? Oh, that's interesting. Judge Frenier's in Dedham now? Hold on a second. Am I missing something? Because I'm looking at the Norfolk County Daily List report, and I'm not seeing any case with Hank Brennan on it. I see a case with Kevin Reddington on it. But I literally have the calendar pulled up. Today's Wednesday the 15th, right? I don't see anything on the calendar with Hank Brennan. So maybe he's in a different court. Maybe he's in district court. Thank you, FKF 2025, for your 10. I appreciate you. All right. What do you want to talk about tomorrow, you guys? What do you want to talk about tomorrow? It's Superior Court. Okay, but here's what I have here. Here's what I have. I have I know you guys like receipts, so I'm going to give you the receipts. Commonwealth of Massachusetts, Norfolk County calendar, daily list report. This is all the 2:00 cases. Over here is the attorney all the way in the column, all the way on the right. See? It's got all the attorneys' names on the right. And as I scroll down this whole list of all these cases for 2:00, which all say Judge Frenier, I do not see Hank Brennan's name anywhere. I mean, you can tell me if I missed it, but I see Kevin Reddington. So I don't know. I don't know. I know we should do some of the witch trials. We should. Carly Gregg's appeal. Oh, that's right. We never did that either because things keep coming up. And that's the thing. I plan shows and then breaking news happens and then we cover the breaking news, you know? So there's that. Co has a teacher. I don't see him on the calendar. All right. Stay safe out there, my friends. Thank you to the moderators. It's been 3 hours and 20 minutes today. You guys are awesome. And thank you, all of you, for watching and spending your day with me. And if something breaks later today, I may be back. So make sure you have the notifications set. Make sure that you have the like button hit. Make sure you subscribe. It's free. And Betsy says, God, your passion is wild and I welcome it. I love you with all of my heart. Thank you, Betsy, for your 10. I appreciate you so much. Somebody recommended Judge Carol Erskine's new book. It was a great read. She was on the Young Jerks at one time, right? And I put up the name of the book earlier. So for those of you who are interested, And look at this. David Wainwright says, UK and gay. Melanie is more glamorous than Faye Dunaway. That is so sweet. Thank you so much. You're very, very appreciated. And New Hampshire woman, thank you for your super chats as I think of that poor sweet girl every day. Thank you. Harmony Montgomery is very, very, very sad case. And Jess says, how is Montgomery already being heard? And it's been almost 20 years for Bateman. Did Bateman's issues just get noticed? Yes, there was newly discovered evidence. And, something was in a drawer, edited audio, and then, a witness statement that just magically revealed itself. So there's that. And then Gigi said, do all these female judges in Massachusetts have the same barber or hairstylist, a Tupperware bowl, and a weed whacker? Thank you. Thank you very much, Gigi, for your super chat. Oh, I wanted to address this. A judge has dismissed the wrongful death lawsuit filed by the mother of Harmony Montgomery. Thank you, Robin. That was a different lawsuit. So she had one against New Hampshire that she settled for $2.25 million. She also then went and sued Adam Montgomery. That case was dismissed because she didn't serve him in time. And so yesterday on Court TV, which I won't play because it was Julie Grant did a piece on it. They're like, where is Adam Montgomery? Is he missing? He allegedly was transferred to some jail in Virginia. I don't really know if it was ever sorted out where he was. But the lawsuit that she filed against Adam Montgomery has been dismissed because she wasn't able to effectuate service on him. It can be, I guess, resuscitated if she can serve him. But so don't get confused because she did settle one against New Hampshire for $2.25 million. Okay. And then I think she filed one also against Massachusetts. And I don't know what this is. My profile can be shared. I'll allow it. I'm not sure what you're talking about. I don't know what profile you're talking about. All right. Peace out, my friends. I will see you tomorrow, if not later today, but I don't think anything else is going to break because the breaking thing that we were waiting for, we covered at the beginning of the stream, which was Kelsey Fitzsimmons. And so say some prayers tonight for Harmony Montgomery and for Kelsey Fitzsimmons and for Kelsey Fitzsimmons' baby that hasn't seen his mother in a very long time. And for anyone else who you think needs our prayers, it's a jungle out there, you guys. Stay safe. And also stay cool, stay kind, stay classy. I know you could do it. I really, really know you can. Thank you, Mrs. Bouquet, for your super sticker. Peace out, my friends. I'll see you real soon.